Ms. Maxwell, would you read into the record the public disclaimer?
Notice of the January 10th, 2018 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate Commission website since November 1st, 2017. Additionally, this month's agenda has been posted on the website since Friday, January 5th, 2018.
All right, now if you will, for the record, call the roll.
Commissioner Gary Bloom. Here. Commissioner Rick Douglas.
Here.
Commissioner Marsha Franks. Commissioner Diane Hills.
Here.
Commissioner Johnny Horn.
Here.
Commissioner Austin McMullen.
Here.
Commissioner Fontaine Taylor.
Here.
Commissioner Bobby Wood.
Here.
Chairman John Grease.
Here.
You have a quorum.
Thank you. At this time, it's my pleasure to welcome officially back Johnny Horn, who's been absent for a couple months while he's been instructing orthopedic surgeons on how to replace knees. And it appears like you've done a good job of getting that done, Pastor, and we're happy you're back. And if you would do us the favor of leading us in a prayer, and then we'll stand and pledge the flag. Pastor.
Father God, we do thank you for this time together. We thank you for your love. We thank you, Father, that Thou hast provided an avenue that we may disagree with each other, but yet somebody who can tell the difference. And Lord, we just pray that you would help us, give us the wisdom.
And please stand.
Face the flag. Think about Francis Scott Key when he wrote those words about bombs busting in the air, rockets red glare, but the flag was still there. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God.
Thank you, Johnny. Appreciate it. All right, you've got the agenda, proposed agenda in front of you. Are there any additions or deletions? Motion by Mr. McMullen, seconded by Mr. Wood, that this agenda be approved as submitted. The chair, before we vote on that, would like to, at some point, discuss the invitation that this commission has to the Tennessee Realtor Spring Conference. So if that's okay with you all, we'll put that down under commission discussions. All right, you've heard the motion to approve the agenda as I have slightly modified it. Any other discussion? If not, let's vote. Those in favor of that motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Next up is approval of the minutes from our December 6th meeting, 2017. Is there a motion?
Move to approve.
I have a motion by Mr. McMullen, seconded by Ms. Taylor, that the minutes be approved as submitted. And once again, I'll editorialize before we vote. Excellent set of minutes. Thank you very much. All right, let's vote. Those in favor of the motion vote aye. Aye. Those opposed, no. Motion passes unanimously. Thank you. All right, we are to medical waivers. Ms. Maxwell, Patricia Green.
Yes. So per the request at the October meeting, I've just summarized this for you guys. Ms. Green has submitted a letter explaining her family's hardships over the last couple years and during the time her license was due for renewal. It expired on 10/8/2016, and she reinstated on 8/1/2017. She is the primary caretaker for her mother and sister, and a doctor's note was submitted to support the information.
What is she asking for?
Reimbursement for the late fees.
She has her license back and it's active, and now, after the fact, she's come and asked for reimbursement.
Based on everything that she was dealing with at the time of the renewal.
How much is that request?
I believe it'd be roughly $1,000.
All right, commissioners.
So does this meet the requirements of the rules that, as far as reimbursement?
Yes.
Okay.
And I was just quickly trying to look for anything medical, and I was just running.
So I left that information out this time, kind of based on our discussion at the October meeting. She submitted the doctor's note and what her sister and mother were going through at the time. I just thought, based on what we talked about at October, that y'all would just kind of want sort of the basic facts.
But but she was doing business or just staying at home?
Basically staying at the hospital during the time this was all going on. I can read the letter that she submitted.
Let's do that, if you don't mind.
Okay. To whom it may concern, I am requesting reinstatement for my retired affiliate broker license. I have had my license for many years and had never had a lapse in my renewal. Last year, 2016, was a year of many health-related hardships for my family. My husband had 4 different injuries, 3 different surgeries last year, and 1 this year. My mother has dementia and lives with my sister. I assist my sister with my mother's care. However, my sister was diagnosed with breast cancer and had to have a double mastectomy and treatment for breast cancer. I became my mother's caretaker as well as assisting in my sister's care and recovery. I did not see/receive my renewal notice. I called 7/24/17 to check my renewal because it renews in August. I was shocked to find out it had been lapsed since 8/7/16. I would like to request that an exception be made to waive the penalty fees due to my family medical hardships. Thank you for your time and attention.
Gordon. Would you scoot up the microphone?
I'm sorry. Exactly what are we paying her for? For monies that she spent, or?
She accrued a $1,000 late fee, and that's what she's asking for reimbursement for.
Bloom.
Is her license active now or retired?
It's still in a retired status. Well, let me double check, but yes, I believe it's still in a.
Paid the money, then she probably got reinstated, wouldn't she?
Yes.
Okay.
I think she's back in. I just wanted to confirm that she's in the retired status. She is in. Her renewal has been extended.
But it's retired. Her license is retired.
Let's check on that and see.
While we were on hold finding that out, I think it would be a good idea to ask if their license has expired, have they been doing business as a realtor during that time?
She's been retired since 1993, so I would assume that she's still
Okay,
in
all
that
right,
retired
then.
status.
Okay.
She's currently in a retired status.
All right, Commissioners, the floor is open. Mr. Bloom?
Not active in our business, and she just has been paying for the.
Can you speak into the microphone?
Okay, is she just asking for the reimbursement of the late fees? And she's-
Correct, yeah.
Well, I'd move that we deny her request.
All right, there's a motion. It's offered by Mr. Bloom, and that motion, if a second follows it, would put to a vote a motion to deny the request. Is there a second?
I'll say.
All right, so properly on the floor now is a motion offered by Mr. Bloom, seconded by Ms. Taylor, that this request be denied. Discussion.
May I ask the question?
Sure.
We got to $1,000, because I want that, I mean, she paid it her license was due to be renewed in August, and she paid it in September, and she accrued $1,000.
So her license expired in October of 2016, and
Oh,
she
16.
reinstated
Oh, I got you.
in August of 2017.
All right, other discussion?
I thought Commissioner Bloom was going the other way with his motion when he first did it. I kind of feel maybe the opposite. I kind of feel like she's just trying to keep them in retirement. I do, and I have my broker's hat on too. I'm like, where was the broker during all this? I mean, but that's a different story. So I don't know. I'm feeling like more to give it back, but we'll see how it goes.
So there wouldn't be a broker in retired status.
Well, you're right. Never mind.
It's,
That's right.
I hope, because if I'm have to
That's
keep
right.
track of my
That's
retired
right.
people.
And when that answers the question, there was nobody to ask if she's been doing any transactions because there was no broker. Okay.
I don't understand why we should honor what our rules say we are allowed to collect from somebody who's not in our business. She's not active since 1996.
But evidently, she did pay that money, though, is that right?
Paid to renew her license, but she paid it evidently late, or anyway, there's late fees that accumulated, and she wants us to be responsible for that. I don't think I am.
I think we have a rule. I'm sorry, go ahead.
Go ahead, you got it.
I was going to say, I mean, we have a rule that provides for the fees to not be charged or to be reimbursed under these circumstances. And if we don't like that, then I think maybe we ought to look at changing the rule. But until we have the rule, until we do that, it seems like we have the rule, and that if somebody meets the requirement to not have to pay these fees or to get reimbursed for the fees that they paid, then I think we have to honor that.
Is that for late fees?
Yes, it's a waiver of late penalties. They can request it as long as they have a doctor's note and a statement to the commission.
Got a doctor's note from 96 to 2018?
Well, she was in retired status until just recently when her license expired. And then she paid this to get it back into retired status.
So she had been paying the fees all along.
She's been paying the fees every 2 years since '93 to be in retired status.
How did we get to $1,000 in just 1 year?
It's $50 per month for the first 120 days, and then it jumps to $100 a month until you get to the 1 year mark, and then you can't be reinstated.
She got in the request before the 1 year?
Yeah,
ran
she
out?
hit it at about month 10, 10 and a half.
Okay.
I'm not sure I'm going to vote on this, but the note she provided from a doctor had nothing to do with her health, right? It had to do with somebody she was taking care of.
Correct.
Now, is that what the rule is set up to do? That's where my confusion is.
It says personal or family health
Okay,
issues.
that answers that then.
And that's what I was looking for. So could you tell me what
It's 1260-01-.21.
But it's not a
Hey.
rule that we granted, it's a rule that we consider it.
1260-01?
On page 76.
Paragraph.
The bottom of 76 and the top of 77. We granted waivers previously.
For
For-
family members? Yes.
Commission also would have the latitude to say, we'll split the difference with you and refund half of it, right? I mean, we have that latitude as well, or is it all or nothing?
There's no restriction in the rule that says you can't do part of it.
It says if the commission grants the medical waiver request, then renewal fees must be paid and all other conditions for licensure must be met but late penalty fees will not be assessed.
That's the $1,000 we're talking about.
That's her $1,000, yeah.
We have a motion on the floor. Mr. Bloom?
Ask the vice chairman something. So
Please.
in your reading of that, they qualify for this?
That's my reading, and I mean, the executive director has seen the actual documents and said that they meet it, and legal counsel says they meet it.
I withdraw my motion.
All right, the second also needs to withdraw her motion, if that's appropriate. She does. So the floor is open now for a motion. Ms. Hills?
I just have one question, because in my book, I have made a note about number 1, not number 2, correct?
Yeah, it's just 1A.
Yes.
A1.
All right, once again, the floor is open. Mr. Wood?
I'll make the motion that we refund the late fees for Patricia Green.
Second by Commissioner Horn. Now discussion on that motion. All right, I sense discussion is done. Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you, Commissioners. Sandy Kirk, Ms. Maxwell, what can you tell us about this lady, or gentleman? Is male or female?
I believe it's a female. She expired on 9/6/2017.
For license.
Sorry. Correct. Her license expired on 9/6/2017. She paid the late fee with her renewal fee on 11/21/2017. She submitted a letter, which I can read if you would like, requesting. She was the primary caretaker for her mother, who passed away at the time her license was due for renewal. And a doctor's note was also submitted.
All right, Commissioners, discussion on Ms. Kirk.
So
Want me to read the letter?
So was the hardship that a parent passed away?
I think she was also the primary caretaker for her mother, who was in. I can read the letter if you want, but I believe she passed away at the time. Hi, Sherry. Thank you very much for your help. As requested, I am letting you know that I have paid the reinstatement fee and also the renewal. I have a confirmation email that I sent to you as well. I will be getting with my mom's doctor after Thanksgiving. I'm writing to the commission to let them know that I take my career very seriously. My mom was diagnosed with terminal cancer stage 4 on May 4th of this year. She was given 2 months to live, and after we went through a 48-hour round of chemotherapy with her, she decided she would not and could not take this course of action. I spent nights in the hospital with her, and every moment I could to encourage her and pray with her and talk with her and love her. I did get behind on my classes and did not mean to at all. My mom was my focus, and I never gave up on her and the fact that God could move the mountain that stood before us. But when she passed away with me lying beside her, and do you want me to
I think that's good enough. Commissioners,
Now, was her license retired, or he was an active licensee?
I believe she's an active licensee, but we can confirm that.
if she was active. Our fact checker is working on it right now.
September 6, 2017. And let me see. Her mother passed away in August. She's active.
We give them a 6 months notice, right? Correct?
No, she paid in November.
Correct, gives you a 6 months notice, correct?
Not necessarily.
Oh, she paid the $80. She did not do the classes, and then so she actually renewed in November.
She had to do education and pay. She only paid, didn't do the education. That's the
Correct, and
situation.
then she paid the late fee at the time the education was done.
Okay. Taylor, I believe you have the floor as far as I'm concerned at this point. You have any more thoughts? Well, feel free to speak into that microphone and give us something to work on.
Well, I'm trying to clarify that we give them notice 6 months before their license is due. Is that correct or incorrect?
It's
To
90,
them and to the
90 days.
90 days. Okay,
Not
so
a
that falls in
requirement that
that.
we do
That
that.
falls in. But
It's not a requirement that we send that,
Yeah,
so.
I do know,
Yeah.
I know that, but I just have a feeling, I think I deny this. I make a motion to deny this.
Second.
I have a motion by Ms. Taylor, second by Ms. Hills, that this request from Ms. Kirk be denied. Discussion on the motion.
I just want to point something out. I mean, I think nowadays, not only does the commission send notice, but some of the individual real estate schools are giving lots of notice too. Because, I mean, I get phone calls saying, hey, do you need some? You got this coming up. And so my agents are getting that too. So there's a lot of notice out there. And,
So,
you know.
and I just want to be sure, so it expired September 6th, so before expiration, she paid the renewal.
She paid her renewal fee. She failed to complete
Before
her
expiration.
full. Yes.
But had not taken education.
She had not taken her full CE courses.
Which online can be done pretty quickly, even in the privacy of your own home.
Further discussion. Okay, the motion on the floor is to deny the request. If you're in favor of that motion, you'll vote yes. If you're opposed, you'll vote no. All right, let's try this by voice vote. Voice vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no.
No.
No. It appears to the chair that the motion passes on a 6-aye, 2 no vote. Grease and Douglas voted no.
Roll call.
You want a roll call on it?
Yes, sir.
All right, we can do that. Ms. Maxwell?
Commissioner Gary Bloom?
Now, the motion is to deny?
Yes. So a yes vote means you support the motion to deny.
Yes.
Commissioner Rick Douglas?
No.
Commissioner Marcia Franks? Not here. Commissioner Diane Hills?
Yes.
Commissioner Johnny Horn? Commissioner Austin McMullen?
Yes.
Commissioner Fontaine Taylor? Commissioner Bobby Wood?
Yes.
Chairman John Grease?
No. So, that confirms the chair's earlier announcement that that motion passes on a 6-2 vote. All right, let's move on. This is something on the agenda I'm not aware of. Ms. Maxwell, a summary, suspension, informal conference. What do we have here?
I'm going to turn it over to Erica.
Okay, Erica, good morning.
Good morning.
Would
How
you
are
prefer to stand or lean over and talk into that microphone?
I can stand up.
Please come up and
Okay.
stand.
We probably need to wait until exactly 9 to make sure he doesn't show up because that's when notice was given for him to be here.
Let's go to the education report. Education Director Ross White, Ross White, is here, ready to make his report. Let's
Mr.
talk about
Chairman.
courses first, Mr. White.
Mr. Chairman and members of the commission, Happy New Year to everyone. I want to call your attention to the education report for the first month of this year, January 10th, 2018. I've reviewed all the courses, the instructors, and the providers that were submitted to me in the interim since last month. I submit to you J1 through J31 to be proper in all forms with our laws and rules.
All right, is there,
Move to approve.
there is a motion
Second.
to adopt the Education Director's recommendation, offered by Mr. McMullen, seconded by Ms. Hills, to approve courses J1 through J31. Commissioners, does anyone want to pull a particular course out of that recommendation before we vote? Since not, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Thank you,
Mr.
Mr.
White.
Chairman, members of the commission. Furthermore, I would like to submit the instructors also before you that need approval, also J1 through J31.
Approve.
Motion by Mr. McMullen, seconded by Ms. Hills, that the Education Director's recommendation be adopted and these instructors be approved.
There's just two, right?
Yes, sir.
All right, let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Any questions for the Education Director about education in general and the Real Estate Commission? I recently had to take my continuing education for Kentucky. They have like timed courses.
Right?
Do we have timed courses?
Timed courses.
Like, it keeps track of how long I'm spending taking this course to make sure I get the full 6 hours of the core class, let's say.
Well, 50 minutes equals 1 hour. They
Right.
should be, instructors should be aware of that as they submit their submittals.
Well, so I did it online, so that's the timing I'm talking about. Do we have courses? Okay, I just want to make sure.
Not all of them, but some of them.
Okay.
Come up.
May I ask a question
Sure.
on top of that? Isn't it true that it locks you in? You can't get out of the computer for a
Some of these online providers do have some mechanism that does that. I understand that is true.
Johnny?
Yeah, you kind of skipped me when we were talking about the previous. Realize, your integrity. Also written in the instructions that these people has been checked, or rechecked. But I was wondering if you could say that when you present a slate of officers to be accepted, because that's the first thing went to my mind. I don't know them, and I need somebody's word that they're qualified.
Absolutely, Mr. Chairman. As I review them, then I check to be sure that the courses and the providers and the instructors are in compliance, but then I do some background checks and looking through their information to be sure that they are who they say they are.
You won't have any problem telling us that, though, will you?
No, sir.
Okay, thank you.
All we need is one rogue instructor that Ross recommended, and he's gone.
No pressure.
No pressure at all, Ross. All right, any other questions for the Education Director?
Chairman, members of the commission, members of the commission, just 1 second. We do have in the audience one of the course instructors and new providers, and she's here to just observe, and I understand Ms. Michelle Moore. I'd just like to draw that to your attention. She has a new course. She is an instructor already approved, but she is becoming a new provider. And her course today is very interesting. It will be and provide a new designation for Tennessee agents. And I thought that I would draw your attention to that. I think that's very important. I don't know of anybody else in my time here that has presented something to us that would actually equal a new designation.
Ms. Moore, come up to the microphone. We're trying to get to 9 o'clock, and so if you can get a little publicity. Tell us about your course, what you do, where you work, that kind of stuff.
So, as Mr. White said, I am already an approved instructor. I've been speaking and teaching for the last year, specifically through the Tennessee Real. I have been working under John Giffen, and so I've had a license. I've been licensed for over 21 years. I'm also a published author. I've earned over 40 sales and leadership awards within the real estate industry, and some of those are national awards as well, so as a top salesperson for different home builders throughout the country. And so I have sold quite a few homes, and when I ran Keller Williams Nashville, which is out of Green Hills, I realized how many people didn't know how to sell. I had 115 agents that I was managing, and part of my position was to coach and help those top 10% producers, and I realized how many really just didn't know the principles of teaching or of selling, and so I decided to do the book. And the book earned an international award in business and finance books. It's done really well for me. It's been out for over 4 years, and so the program is the follow-up to the book. A lot of realtors say, "Oh my gosh, how do I get more from you?" And so I quit doing one-on-one coaching and team coaching and decided that I was going to focus on doing something bigger. So this is actually a national designation. So I'm going through some different steps to potentially get continuing education throughout the country. And so this is my first step with Tennessee.
Commissioners, any questions for Ms. Moore?
What is the designation?
Yeah, let's start with that question. You're next, Johnny.
So a realtor designation is the letters behind your name. So when you see
No, not what is a designation. What is this specific
and so
designation?
it is the RESP designation, which stands for Real Estate Selling Professional. So.
Yes, ma'am. I respect the job you're doing and your credentials, but what I'd like to know, what are you doing teaching a course or selling books?
The course, the book is included with the course. But what I'm really doing is teaching realtors how to be able to sell and to be able to meet the goals that they have. Everybody has different goals, and so I'm really trying to help equip people, realtors, to be able to do what they want to do. So.
That answer your question, Mr. Horn?
I guess.
Other questions for Ms. Moore or comments? How was getting the course approved process? Was it arduous, easy?
Oh, it couldn't be better. Ross White is phenomenal to work with. And I met Ross, like he said, I'm an instructor, so already with the state. And of course, John Giffen has been a great mentor for me as well. I've been with Benchmark Realty for years. And so, but Ross helped connect some dots. If you've been a realtor for years, but you have never been an instructor, you know, it can be a little intimidating. You don't know really what you're doing. And so he was just wonderful. I've called him and been very responsive. I couldn't have asked for more. He's absolutely, I have to say, absolutely an asset to this state.
Else, commissioners? So,
I'll make one comment. I remember when I was in college, some years ago, Dr. had wrote a book. I kind of, asked him questions about the book, like I was really interested in this thing of his book. And most of the time they would mellow out and say, yeah, if you're really interested, do this or do that. So I'm just wondering, I'm sure it needs to be in your credentials, but whether you have written a book, does that have a lot to do with the course material that you...
Well, what I did was, so the book is Selling Simplified, 55 Fast Tips to Jumpstart Your Real Estate Business, and I took 16 of those 55 tips and dug deep. So obviously, when you write a book and there's 55 fast tips, they need to be fast tips. So it was about the 4 stages of learning. The 4 stages of learning starts with unconscious incompetent. Realtors, when they get their license, they don't know what they don't know, right? I know at least I was that way. I was very young when I got in business and didn't know anything about marketing, setting a budget, all of that kind of stuff. And so the goal for the book was to take realtors from stage 1 to stage 2, which is conscious incompetent. I'd never heard of personality types, and so I didn't know there were stages in selling. There were a lot of business principles I just didn't know. And so the book goal was to take you to that stage. The designation is to take you from stage 2 all the way through stages 3 and 4. So stage 3 is conscious competence, which is where you're going through the stages, but you know exactly what you're doing, you're thinking about it. And then unconscious competence is where it's just second nature. I've had people say, you believe in such a thing as a natural born salesperson, because I think you were that way. I had that early on in my sales career. And so, but most people don't have that, but you can get there through practice, right? And so,
I don't mean to interrupt your presentation. No. I know you're answering Commissioner Horn's question, but I think his question, you tell me if I'm right or not. You're concerned that an instructor who also has a book to sell might have a conflict of some sort? Is that yours?
That's a bit, but let me simplify it. And if you're teaching a course Why should I go to your course if I could get the book and get the same thing?
You can't. The book only tells you what to do, a little bit of what to do.
All right, thank
Here's
you.
the answer you were looking for. Thank you. All right, Commissioners, anything else? You're welcome to stay at this whole meeting if you like. Do you need continuing education? Do you tell your students that they can come here and get 8 hours of continuing education?
Well, I haven't in the past.
Well, why don't you do that?
I
mean,
will.
just a thought.
Do we get any CE for what she just did?
Not yet, no. Although the course and instructor are both approved. All right, Mr. White, based on what Ms. Moore said, you've got your job secure for another 30 days or so anyhow.
Thank you, Mr. Chairman.
All right,
Commission,
man.
thank you very much.
All right, let's get back to the agenda. The time for the record is 9:04. Miss Erica, we're ready for your presentation.
So I just want to start off with saying that we noticed Mr. Willoughby by email, and I have proof that it was delivered. I got a delivery receipt on that email, and then we sent it by FedEx, and I have proof that that FedEx was delivered, but we have not received any response as to whether Mr. Willoughby was going to show up today. He also did not respond to the last complaint that we had filed against him, which I'll kind of get into here. But is the commission okay with us proceeding?
Tell us would you just, for our benefit, tell us where you're trying to get to.
This is an informal conference to determine whether or not Mr. Willoughby should be summarily suspended.
He's a licensee.
Yes, he is a licensee.
Okay.
So, when you say informal conference, at the end of this, would we make a decision whether to suspend him?
Yes, and I'm gonna explain all of that. Yes, but at the end we would. Okay, so the department brings forward this matter for possible summary suspension. 5 complaints have been filed with our department against the respondent, Mr. Willoughby, and those 5 complaints were presented at the December meeting. And the commission decided that they authorized a consent order for revocation of his license along with a $5,000 civil penalty, combining those 5 complaints. In the interim, since then, we have received notification from the Better Business Bureau of their concern about the number and nature of the complaints that the BBB is receiving. The BBB Director of Operations is the one that contacted us, and she stated that they have received 10 complaints since 2016, with the majority being received in 2017, so pretty recently. And the respondent most recently responded to a pending BBB complaint stating that the complaint should not be against his company or companies. The respondent mentioned 2 companies, Willoughby Realtors Incorporated and Willoughby Realtors Leasing LLC, and he stressed that they are different companies, but the complaint should not be against either one of them. The Director of Operations did not go any further into that response, but that is what she provided to us. She also said she went onto the respondent's website and reviewed the application that they provide, and it was her opinion that any consumer would consider the 2 companies one and the same. The companies seem to use the names interchangeably as well as the addresses that they are supposedly doing business at. The Director of Operations also states that aside from the complaints about the respondent's company's customer service, there are some serious allegations mentioned in the 10 BBB complaints. The company has had an F rating with the BBB for years, but because the complaints are picking up in pace, which was in their words, they wanted us to know about that. So we thought it was important to present that to you as well, in addition to the fact that we have 5 complaints that were presented in December. All of the allegations are quite similar as to what's going on. It seems like it's the same scam. And TCA 45320 allows our agency to summarily suspend a respondent if the public health, safety, or welfare imperatively requires emergency action and incorporates a finding to that effect in its order. A summary suspension may be ordered pending proceedings for revocation or other action. These proceedings are to be promptly instituted and determined. Summary suspension proceedings are not a full hearing, but an informal conference where the respondent has an opportunity to appear and respond here as to why immediate suspension of his license is not warranted and why he is not a threat to the public health, safety, and welfare. So the only issue to be resolved today at this conference is whether the conduct rises to the level of being a threat to the public health, safety, and welfare. So no matter what the commission decides today, if the respondent does not agree to the consent order that was authorized in December, there will still be a full hearing on whether his license will be revoked, and that penalty will be assessed. But we felt it could be that kind of an emergency where we would like to possibly summarily suspend him until then.
Johnny, can you talk into the microphone?
You said a phrase that I wasn't sure that what side of the fence it was on.
Okay.
And the reason being, I'm not a lawyer, I'm a public member, and but we do have people who is quite adept in that area. But you said the same old scam. Have you convinced yourself it is a scam, or whose job is it to do that?
Well, when I presented the 5 complaints in December, I went into great detail as to what the scam is, and I can go into it again if you'd like me to. But the reason I use the word scam is because I guess between the 10 BBB complaints and our 5 complaints, all of the allegations are about the same issue that is happening to the consumer by this respondent taking money for the same reason, and it does seem to be a scam.
Request, Johnny, would you like to know what the details of the alleged scam are? Or would any commissioner like to hear that?
Our struggle is, you know who it is, and you've been able to match all this up. When we heard about it in December, all we knew was it was respondent.
Right.
And so today we got a name, and we're sitting here going, okay, which one of these people was it? And that was a month ago.
Right.
So when you just made that comment, it sounds like to me there was somebody that was taking deposit money in.
Yes. Like the respondent was taking deposit money in from prospective tenants, and it seems to be he's taking deposit money for one property from multiple tenants, and he somehow blames it on a property management company, and basically at the last minute, right up before move-in date, like maybe the day before, 2 days before, the respondent would tell all but one of those tenants he collected the deposit from some excuse as to why they couldn't move in. The owner decided to rent it to someone else, or whatever.
And he couldn't get the money back.
And he would say that sometimes he would say you'll get your money back within 7 to 10 days, and so nobody is getting their money back.
Hills.
And the request has been made. I remember these cases very well, and I looked them up in December minutes, and it was quite disturbing to me. But I noticed, looking back in my December minutes just now, he's a principal broker.
Yes, he is a principal broker.
And that was a fact I didn't remember last month, or I didn't pay attention to.
Oh, his last name serves as the
I don't know anything about the name means nothing to me. So my motion is to take his license.
Summarily suspend.
Summarily suspend.
Motion made by Ms. Hill, seconded by Ms. Taylor. Procedurally,
Because the public health, safety, or welfare imperatively requires emergency action, right?
Correct.
That's part of your motion.
That's part of my motion.
Did I hear that we couldn't revoke his license at this time?
Not,
We
yes,
cannot,
not,
okay.
but we can if he doesn't sign the consent order. Can I add one more thing that,
I let
Sure,
Mr. Boyer
sure.
have the floor just for a second. It'll come back to you.
Well, I was just curious, is this just against him and not his company? And that's
Five-
what the Better Business Bureau is suggesting, but I don't know that we...
The 5 complaints that were filed with our department are just against him as a principal broker. The Better Business Bureau complaints, I can't say for sure if it's against his companies in addition to him, but I do know that they're against him as a principal broker.
He's a principal broker of this firm,
Right.
and we can't do anything about that? It's just against him?
Well, we'd have to open a complaint against the company, and I think it'd be best to, I think he is the alter ego of the company. I think he is the company.
Yeah, he is.
And so I think if you take action against him, you're taking action against both. Now, if somebody steps in and becomes the new principal broker of this company, that may be a different thing, but
So, Ms. Smith, we're going to get back to you, I promise you.
Oh, of
So,
course.
there's nothing that would preclude this commission today from asking that a complaint be opened up against both real estate firms based on what we've.
correct.
So that may be a motion you might want to consider, Mr. Ms. Smith, I interrupted you.
Oh, no, I feel like I interrupted you. I just wanted to mention this, and I did bring it up in December, but the first 4 complaints that were filed, the respondent responded to, and his responses were, in my opinion, cut and paste from his last response, and then he would add like a sentence at the end to kind of make it fit with that complaint. But it just made it seem to me like it wasn't taken very seriously. And then the 5th complaint, he didn't even respond to at all. So that's another reason why I feel like it could be an emergency situation, because I feel like he might not even be at the same address where we're going to have trouble locating him if we were to wait. So I just wanted to bring that up as well.
Ms. Hills?
Are there any other agents in this firm? Do we know?
I don't know offhand, but that's something we can definitely find out.
To see
I
who's
think-
passing the torch?
So can we assume that he's the principal broker of both firms?
Yes, yes.
Okay. All right, other discussion. Mr. Green, did you have a concern? I've got a concern about your face. I mean,
My face always looks concerned, Mr. Chairman. I can't help it.
It's clean shaven in some form or fashion.
Yes,
Mr. Horn.
Yeah, so let me go back to what we were saying again is I guess you would be considered the
Step up the microphone there, Johnny.
Yes,
in the
and that.
the charges, and again as a public commissioner, I think that we need to refrain from putting labels on people until it is proven. You know, let's face it, the average person that we get has violated something, but to say it was a scam, and then I would want to have to come back and eat that up if it was proven that, you know, probably never can. But I just think we ought to refrain from putting labels on people until we.
And Commissioner Horn, we had the luxury of reading all these last month that you did not. I mean, when you read the different complaints, I mean, it was a scam. I mean, it was the same thing. I mean,
Not taking your advice at all, Johnny.
It was a scam. I mean, it was obvious, and doing something this quick and rapidly, I mean, I think is the right answer. I mean, it is somebody's taking advantage of some people that are scrambling, trying to find a place to rent. He's taking their deposit money, promising things, and then not giving it back. When who knows if he's even got properties or not that he's doing this for? I mean, he's taking advantage of some people.
The old saying, if it looks like a duck and it walks like a duck, you know.
Back in, yeah.
And,
Yeah.
Good point.
Thank you.
Ms.
Yes, I agree.
Smith, so if this motion passes, procedurally, what happens next? What does it look like after the vote?
Correct me if I'm wrong, Mark. We would immediately suspend his license through the licensing division, we would send a notice to him that his license was summarily suspended, and then we would also send the consent order. No, we would not.
No.
We would just set a hearing.
Yeah, we would. At this point, once the summary suspension has gone into effect, if it goes into effect, the consent order basically is off the table, and we move forward to a notice of hearing and charges. Now, if he wants to negotiate, then obviously, we would bring that back before the commission. If he wants to enter in voluntary revocation of some manner, then we could provide a consent order. But it moves forward to a hearing at some point.
I recognize Ms. Taylor. Does it take priority over other hearings? If it's a threat to the public, don't we try to get this handled as quickly as we can?
Yes. I mean, the statute basically says the state has an obligation to get it within a reasonable amount of time. So your interpretation of that is yes, it would. We would need to make effort to not let this linger for a year or something of that nature.
We'll come to the microphone too, please.
My question is, in December, we voted a $5,000 fine and suspension.
Revocation.
Revocation.
Yes.
And so when would that take place if we let things go?
That's when, if you decided to summarily suspend him, we would expeditiously set a hearing in front of the commission to a formal hearing on that exact, those 5 complaints. So basically, we're taking away that offer of settlement in the form of a consent order. So you would get a full hearing on the 5 complaints that you heard in December, and then you would get to make a final decision on whether or not he would be revoked, and then those penalties assessed. And then he would have the opportunity, of course, to defend himself at that hearing. Did that answer your question?
That's if we left things alone, and the time frame would be out here to get all that done, correct?
No, if we move forward with the summary suspension, the consent order's off the table.
Yes.
Because we
just set a hearing.
Yeah, we set a hearing,
Okay.
and then at that point, the commission will determine, A, whether he's violated anything, and B, what penalties would be assessed.
And that would be I would imagine, the next board, I guess the day after the next board meeting that we can set it for.
All right, the motion on the floor is to summarily suspend the real estate license of Anthony Willoughby. That proposal was made by Ms. Hill, seconded by Ms. Taylor. Is there further discussion? If not, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Do you need a roll call vote for any reason on this particular? Johnny Horn.
I wasn't here in
I'm sorry.
December, so I feel like I need to abstain.
Mr. Horn abstains. So on a 7-0-1 vote, that motion passes. No need for roll call.
No, Mr. Chairman.
Now, I'm not asking you. Sometimes on these, when they get to this kind of level, they want to make sure everybody's recorded. All right, Ms. Smith, thank you. Mr. Green, are you here for any other reason? Other than to wish us a Happy New Year?
Happy New Year.
Show off
I'd show off his face.
Yeah. My wife got tired of it.
I don't blame her. It looked awful. It was terrible.
Nice to see your face again, Mr.
Wait a
Green.
second, Mark. Gary?
Yeah, I'd like to file a motion that the commission file a complaint against the Willoughby Real Estate Company and the Willoughby Property Management Company for the activities that we have already discussed about Mr. Anthony Willoughby today.
Is there a second to that motion? Second by Ms. Taylor. Is there discussion? There shouldn't be much discussion. We'll have to get the complaint filed and see what kind of responses we get. All right, let's vote on the motion. Those in favor vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Anything else? Can we let Mr. Green go? Thank you, Mark.
Thank you, Mr. Chairman.
Thank you. Can I sit for the legal report?
We're not to you yet, but you can certainly.
Okay.
You've got to go through some other stuff with us first. All right, we're to the Executive Director's report. Ms. Maxwell, you submitted a report to us. Is there anything in particular you would like to highlight?
Really, I would just like to highlight the staff. There's been some changes over the last couple months, and we've been without an office manager. And every staff member has really risen to the occasion and, exceeded expectations. So just want to say a quick thank you to them. And also, I would also like for us to go ahead and vote on the Arillo. We'd like to get the travel paperwork started for the spring conference. I have the dates and who's gone to the last couple. The dates of the conference are April 4th through the 7th, and it's in New Orleans.
Yes, we've been fortunate to get at least 2 staff members to go and 2 commissioners. Is that correct?
That's correct.
And you suspect 2 staff members will go this time?
Yes.
All right. And do we need to tell you who those 2 staff people are, or do you guys get to pick that? You can tell us. A motion to appoint, say, Sarah Matthews and Kaylin Maxwell to be staff representatives to the Spring Arillo Conference.
I'll make that motion.
Thank you, Mr. Bloom. Seconded by Mr. McMullen. Is there discussion? Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes. Now, we also need to, are we assured of having at least 2 commissioners go, or, we always struggle, it seems to me, getting approval from people on the 5th or 6th or 7th floor, whatever it is.
So Sherry has been kind enough to go ahead and start the paperwork. And so we've already started submitting for 2 to go. I don't foresee an issue, but I think it would probably be in our best interest to go ahead and get things rolling since April could be here before we know it.
So is there a nomination or a suggestion or a volunteer that wants to be included in this?
Didn't we already set out the parameters of how people would go and have a list?
So I do have the list of who's gone to the last couple and then who would be up next. Rick would be next. He was not able to go to Louisville. And then it would be Chairman Grease and then Austin.
So I'm not going to be available. I'm sure of that already. So Mr. McMullen, you're next in line.
Well, Mr.
Douglas first.
Is first.
I got it. We're looking at the second one. Okay. You available? Good. Is there a motion that Mr. Douglas and Mr. McMullen be
I'll make that motion.
the commission delegates? And that's seconded by Ms. Taylor, offered by Mr. Bloom as a motion. Is there further discussion? Now, I'm going to vote on that, and I want to talk about one more thing. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Is there a third person that, if we could, I know it's a long shot, but if we could get approval, that, who would be next on the list after that, Caitlin?
So next on the list would be Commissioner Bloom.
Is not Marcia interested in going to this?
I would assume Marcia will be going no matter what. She typically does.
She's reached out to say that she would be going if nobody else wanted to go.
Okay, well, I'm going to give that slot to Marcia.
By the way, Marcia as the alternative. Okay, is there a motion to that effect? You made that, Mr. Bloom. Seconded by Mr. McMullen. All those in favor of that motion vote aye. Aye. That motion passes unanimously. Now, this commission, as a body, a couple of months ago, asked that she be reimbursed for her registration fee to the Hawaii trip, I think. Do you know if that happened or not?
I am 90% sure that it happened. I can confirm over lunch. We've sent all the paperwork up, and it went back and forth for a little bit. It's much harder to get something approved after the fact, which is why we want to go ahead and do this. But I'm 90% sure that she's gotten reimbursed based on the last approval.
Okay. Thanks. All right.
Can I ask a question?
Mr. Douglas.
Yeah. The Arillo conference is April the 4th through 7th.
Have we made a motion to reimburse Marcia for going to the next one because she is an
The floor is open for such a motion.
I make a motion that we reimburse Ms. Franks to go to for her registration fee.
For registration, okay.
Orleans Conference because she is an officer.
Assuming she doesn't get selected, assume we can't get 3 fully paid.
Right, I mean, that, yeah.
Okay. So Ms. Taylor's motion is to offer to reimburse Ms. Franks for her registration fee to the Rello Conference in New Orleans in April. Is there a second to that?
Second.
Second by Mr. Wood. Is there discussion on that topic?
I put in because she's an officer, because she is an officer.
All about if people want to spend their own dime to go there.
I got that.
And then pay for the hotel that we ought to. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right. Anybody have questions of Ms. Maxwell on any topic since this is the executive director's report?
Microphone.
Hearings. We were discussing hearings.
That's coming up next.
Okay.
We got that on the agenda. Other topics. Mr. Horn, you got to come forward now.
Back to Ms. Maxwell.
Executive Director Maxwell.
Your Majesty. I'd just like to know how the job is going. And
It's going well. We have made a couple changes, and luckily Ross and Aaron have agreed to assist me, and we're really monitoring kind of what everybody's doing on a day-to-day basis so that we can set expectations for everyone. And so that has been really good for me to see, and I think it's also, really good to be able to for the staff to know exactly how much work they're doing every day. So overall, it's going good.
A couple of things. So you've got some of your staff each week working at home.
Correct.
How's that working out?
It's working well. That's part of the reason why Ross, myself, and Aaron began to monitor exactly what was getting approved every day and who was processing it. And since we've sort of tweaked how much everybody should typically be doing and processing every day, it's been going great. I know the staff are loving it based on not being stuck in traffic. We've got Clarksville, we've got Murfreesboro, so it's saving some people 2 hours of their day every day.
Questions. So here's my last question. This director has gently been on my case to get Jackson meeting actually lined up. I think I've done that, but have you heard from Mr. Ward?
Not.
Dang him.
Is he supposed to?
He's got the place reserved.
Okay.
And I talked to him a couple of days ago, and he said, I gave him your contact information. He was going to send me something. I think he spelled my name, and I didn't get it, but maybe you did. So I'll follow up with him. But he's got your contact information, and we're set in the meeting
Perfect.
hall. I want you to know. And I appreciate
Yeah.
supposed to be doing something and hadn't got it done. All right. Let's talk about this legal formal hearing schedule.
Okay, so Mr. Bloom had asked for this to be added to the agenda, and so based on that, I reached out to Erica and Robin to find out, looking ahead, what we have. Erica, I'll let you chime in if this has changed, but it has. Okay.
Just with what we talked about today, that's the only hearing that I will need to expedite, and the only one that I need to set as of this time.
And so as soon as that gets set, we'll make sure that everybody here gets communication about that. Do you have any idea of?
talk to us about not talking to the microphone. You need to say
Busted.
We'll say March.
I think we already have a formal hearing in March,
We
don't we?
do. That's
So based on what I heard back from Robin, and we might let her chime in once she calls in, she says that she has 3 cases that must be before the commission, and she's working to schedule all these with the attorneys. Based on what she said, I think the earliest for her would be in March. She said March, April, and June, as soon as I hear back from the attorneys involved in the cases in question. And then the remainder of what she has is unlicensed and failure to respond matters, which would be heard before an ALJ.
So, just a suggestion, like if this meeting goes like it's going, we might have an afternoon free here, okay? Is it possible, if we're going to have a 2-day meeting, to schedule something for the afternoon of the first day and something for the morning of the second?
I would say what we can do is we can schedule it for the first day. That would mean we would need to, if we can get an ALJ, that's the other issue. I know that they send us their schedule, so we kind of work off of when they tell us they can be here. If we could get one of them here, we would just need to stop our business, even if we're not done, pick up with the hearing, and then, I mean, we could come in at 8:30 the next morning, finish our business, and then start the next hearing at 9. So.
Just random thought. So we're starting our meetings at 8:30 now in the morning. Do ALJs start before 9 o'clock?
not that I've known.
So,
I don't think so.
So on days of formal hearings, we'll be starting at 9 o'clock, not 8:30.
Yeah.
Okay. All right. Ms. Taylor, you were in.
I had a
Microphone.
question, which was about a year before last, we had almost a hearing almost every time, as I recall. A lot, let's say a lot. Last year, we had very few. This year, at last meeting, we were told we were going to have one January, February, and basically through June. All right, now we get to like 2 days before the meeting, and we're not going to have a hearing. How does that happen?
Those are continuation issues. Either the respondent wants to continue, they have an attorney that wants to continue, so they file that continuation and the ALJ approves it. Or, as in some of the cases that Erica's had recently, she's able to settle them right before because people get nervous because they're getting ready to have a hearing, so they just settle and...
Not for lack of me trying earlier, though, I promise. It's just they decide at the 11th hour that okay, I don't want a hearing anymore, I'll sign it.
We already know otherwise that we have a hearing February, March, April, and May. Is that what?
So what Robin has told us
Or
is
think we-
March, April, and June.
March, April, and June.
And so all of Robin's cases that she has, there is an opposing counsel. There's an attorney representing the respondent. And I know sometimes that there tend to be more continuations because they tend to know what they're doing a little bit more than the basic. So, but she is working with all of those attorneys to get these scheduled and get them set.
Well, yeah, so I'm asking this question. We're booked up in March, April, and June, but we just heard Mr. Willoughby's, and we said we'd do that as soon as we can, but we can't do it in February. So the earliest we can do Mr. Willoughby's is May?
I think in that situation, they would probably try to set 2 in March.
Well, that's what we've been begging for, do every month.
No, and that's what I assume they will do. Robin and Erica will probably need to get together and talk about it. It could just be a really long day if one of them thinks that their hearing's going to go long.
I know we were just talking about the possibility of scheduling it on the day of the meeting, if we had time and I could get an ALJ, and I'm willing to do that. If we want to can we make that that tentative decision now?
I would say we probably should reach out to the ALJ today and see if we can get on there.
I mean, if it's okay with the commission, I will reach out to the ALJ today, and I can have an answer for you pretty quickly as to when it's going to be, and if they can confirm that they can be here on the day of the March board meeting.
I had in my notes we had a formal hearing in February. That's not the case?
If that was mine, I settled it. So no.
I don't really care about this, but when you settle something, do you not have to bring it back to us to see if we agree with the settlement?
It's they just decided to sign the consent order, so you already authorized it, the consent order.
Any deviation, you'd have to come back to us from the consent.
Oh yes, yes, absolutely.
And I would say if Erica is able to get an ALJ the first day, they will probably want to start at 9.
That's another thing I wanted to
So
ask.
they'll probably, we would let you know the first day is going to start at 9, or we can come in and do business for 30 minutes, and then we would just pick up when she's done.
All right, let's take about a 10-minute break, and we'll get into legal stuff. Sweet.
Hearing schedule?
I think that was what we just talked about. The agenda and then promptly forgot it, and it had to do with the spring meeting with the Tennessee Realtors, also known as TUR, in my opinion, as opposed to TAR, previously known as TAR. And the commissioner brilliantly, in my opinion, started thinking about that meeting, which I think will be approved for continuing education, 1 hour of continuing education.
That's correct, Mr. Chairman.
Is it already approved?
No, it'll be on the next agenda.
Okay. Suggested that if a majority of the commission was there, that we should have, as a commission, some input in how the meeting went and what the format of the meeting was. I mean, that's a great thought. So I'd like at this point turn it over to Commissioner Bobby Wood, who came up with that idea. And let's just talk about this for a little bit, and I'd like to get your input on it.
Well, this has just been my thought the last 2 years that I've been a part of the commission, and we went over there. It's just been a format where, okay, anybody want to ask some questions? And sometimes we have some relevant questions, but I really felt a lot of the time we spent on questions that pertain to like less than 1% of our membership, and so it really, we kind of got obscure, and I really think we left a lot of information on the table that we didn't get out. My thought is this: I would rather. I mean, if there's some questions, I'm not opposed to taking questions, but I would rather us have some information that we want to present to the licensees, and because I don't think they have any idea what in the world we do. I mean, I think we need to kind of just give an overview of some of the things and changes that we have done within the last year. I mean, I think we need to talk about the 50-mile rule again, and let them know about that. And sometimes too, it might just be good to hear the logic behind that, because I don't think people had any clue that the brokers did not have to live within 50 miles of the office. I mean, all they heard was we took away that the agent had to be there, but nobody ever knew the broker didn't matter. There was no rule for the broker. And so just kind of go along some of those things and a little bit of the logic, because this gives us an opportunity, one of the few opportunities that we have to actually talk to licensees. And that's just, and also too, and I mean, I think it's important too that people, that they know who in the world we are, to some extent. And I think rather than, just getting up there and one of us or two of us just kind of telling everything, almost like everybody comes with their topic. I mean, that you're going to talk about, and then and the chairman can say, okay, Commissioner Bloom, why don't you tell us about what we did about this? About what's the changes in the advertising, about how the sun, and Commissioner Bloom takes off and just does that. That's kind of my thought. And then, we've got a lot more to talk about that we can take in an hour, but so we're going to have to pick and choose what we get. But that's just my thought.
Ms. Hills.
I think it's a wonderful idea. One of the things that now that the holidays are over and we've been to different events and things, socials, I'm finding that so many people think that we know who the licensees are with the complaints. They think we know who they are, or what company, or where they are in the state, and it's just surprising to me. Everybody, I mean, brokers, licensees, they all do, and I'm just surprised at that. So that's an example of one of the things that I think should be brought up. That's just an example, because I'm just surprised. I think I took a class of Commissioner McMullen's, and I think his class was a very good example. And if we look at his class, a very good example of going over what the commission does. I think that was something to look at and would be a very good outline for that.
One thing you might want to do also on the questions, because you do get some off-the-wall questions. And like you said, very laser focused in on one issue that doesn't apply to anybody else in the room. We might recommend to them that if we are going to have a question and answer time, that if people want to ask questions, maybe they write those down ahead of time, and you have a moderator who then goes through the questions and picks the ones that maybe have some more relevance, if that's possible. I see a lot of laughing and head shaking, so I'm wandering into something that I don't know about here, but just an idea.
Historically, the moderator has been the chief lobbyist for the Realtor Association, and sometimes he's got a note that somebody read, but he's making his own question up as he goes, I suspect, which is something that's important to him, but not necessarily to the person who wrote the note. So, I don't think if we started the meeting and introduced Fontaine from Memphis, and Fontaine, what do you have to say to these people, and you had one little bullet point, we would at least have some control of what direction the meeting may go in. And it can be simple stuff. I'll take the one that says, every time we receive a complaint, we file a complaint against the principal broker. Well, they don't know that for failure to supervise. And maybe talk about the logic a little bit. Those, I think, Bobby, is a great idea. When you look at that course and get ready to approve it, I need for you to take our comments into it.
I think it is too, but I think it would be great before the meeting that we as a group come up with the important issues that we want to hit.
And we've got 2 more meetings before that session, so that I just wanted to see if you guys like the idea, first of all, and second of all, just be thinking about the calls you get from agents and what they're about and how we, as a body, address those issues. I think it'd be important. Thank you, Bob. Other comments about that at this point? Just be thinking about those issues, and in the next 2 meetings, we can start maybe getting a list of 9 bullet points or 8 bullet points.
When is the presentation?
Sometime in March.
March 20th, 1 to 2. It's on a Tuesday.
Way in the back of my mind, I've played around with the idea that maybe you could have a formal hearing that morning, and then everybody would be here, and then they could go down. When those things.
Never know how long, because I was in court in Wilson County last year.
Right, that's right.
You could have the formal hearing at the conference.
We're going to have it at the conference in front of everyone.
Mm-hmm.
Yeah, that's got train wreck written all over
it.
All right.
That's
Mr. Bloom.
Give us Barabbas.
Well, it'd be good to get Russ on board with what we're talking about.
Well, we're going to approve his course. But I'll talk to Russ.
Okay.
And really, Russ, I'm not even sure if Russ is going to be there or if Jennifer is going to be doing it. I don't know now what that setup.
Government affairs. So.
Well,
that's true.
So I'm just not sure.
I've reached out to Jennifer, but I have not heard back about this idea.
Perfect.
As long as we got Commissioner Grease there, we're okay.
I had to answer a lot of questions last year. I didn't like that as much.
You answered them right.
We're on the schedule, because I
Yeah.
wrote it on the appointment book.
All right, Mr. McMullen, if you'll pick us up on the recommendation section of our agenda.
Okay. What is, at 10:15, we have recommendation cases 2015-022-4251 and 2015-022-427.
So I'll step in. This is, at the last board meeting, this is the matter that was assigned to a board member, Marcia Franks. Yeah, she's not here, so we have her recommendation, and I'll give everybody just a little synopsis of sort of the course of this case. So Marcia has reviewed the entire file and the information and responses provided by both of the parties. This matter has been before the commission. The matter was removed from litigation monitoring in July of 2017 and has subsequently come back before the commission twice since that time. The first time, it was a recommendation for a civil penalty to the respondents for $1,000 each, which was accepted by the board. After additional information was received, legal made the recommendation to dismiss the matter, but the board asked that the complainant be given one more opportunity to respond. It was determined at the last meeting that it would be appropriate for a board member to review independently and give a recommendation to the board as to her findings. She has completed her review and stated, after a careful and long examination of cases 201, 502, 24, 251, and 201, 502, 2427, Commissioner Franks recommends that TREC dismiss both matters. There is no proof that either respondent is guilty of failure to disclose adverse facts or any other violations of the TREC statutes or rules.
Motion to accept.
Second.
We have a motion by Commissioner Hill, seconded by Commissioner Taylor, to accept the recommendation to dismiss both of these complaints. Is there any additional discussion or questions? Hearing none, let's vote. All those in favor of the motion to dismiss, vote aye.
Aye.
All those opposed, vote no. That motion carries unanimously. Chairman Grease was not present for the vote, so the vote was 7 ayes, 2 absent. Okay, now let's proceed to the consent agenda of the legal report.
Can we get Robin on the line on this one?
Robin did just email me, and I believe that we are going to have a hearing in February, but we'll confirm that when we get her on the phone.
So while Caitlin is getting Robin on the phone, are there any matters on the consent agenda that any member would like to remove from the consent agenda for discussion?
Yes.
Okay, which numbers?
So if I just have a question, I guess I have to remove it, don't I?
What numbers do you have questions about?
51, 52, 53. 8.
Hello. What was the last one?
58.
Robin, can you hear us?
So
Just a minute, let me turn off the volume from the meeting, okay? Hold on.
Okay.
51, 52, 53, and 58.
Yes.
Okay. Does anybody else have any matters that they
At
would
47 and 49.
Okay.
And 33.
Hold on just a second, I'm getting it.
You're fine.
Okay.
On that 47, include 48 and 49.
Okay.
Hello?
Can you hear us?
Hello?
Hello, Robin.
Yeah, I can hear you.
Okay.
Okay.
Also,
Yeah.
1.
Number 1. Okay.
Yes?
Any others?
Hold on, Robin. They're removing cases from the.
Wait, hold on a second, please. Hold on.
Okay. I have 1, 33, 47, 48, 49, 51, 52, 53, and 58.
Shoot.
Are there any
Just
others?
a minute.
Hold on.
Is she like around the world somewhere?
No, I'm in my bedroom watching you all.
Quit watching us.
She heard that.
Your radio while you're on the phone.
Although I am not in my pajamas, I am in my sweatpants with my lovely cast, but I can't see you.
Too much information.
And why don't we see you?
Well, I planned it that way. Now, would you please tell me the ones you had a problem with in my part of the consent agenda? Because I had 14 things going on and I couldn't hear.
We are getting there. Hold on.
Okay.
If she's 1 through 30, it's just number 1 now, right?
So, Commissioner Hills, you said you just had a question about 51, 52, and 53. Is that right?
No, just a question on 33.
On 33. Okay, is that Ms. Smith's case?
That's there, yeah.
Robin only has through.
Okay, what's your
30.
question? For
but
Ms.
that's-
Smith.
Let me see. Was there something, was there some sort of danger? I mean, were we missing something? Is there a danger?
No,
That's all.
that was just the complainant's wording, and I feel like I fully looked into that because it worried me too. I wanted to make sure that there wasn't, and I think that there was absolutely no danger.
All right.
She was just
I
very
just
upset
wanted to
about
be
it.
sure that we weren't missing something. That's all.
So
Thank
you're okay
you.
with leaving
Yes.
33 on the
Yes,
consent
I
agenda?
just wanted to be sure that.
Does anybody else want to take 33 off the consent agenda? All right, hearing none. So we are, we're going to take off 1, 47, 48, 49, 51, 52, 53, and 58. Okay. Do we need to read the numbers in of the ones that we're leaving on the consent agenda?
I've got one comment that I would like to make about one of these on the consent agenda before
Which number?
Let's see. Number 44.
Okay.
The respondent sent an email to the complainant, and I thought it was important to just read this quote that the respondent said in this email to the commission. She was referring to, the respondent was referring to if the complainant decided to file a complaint, and this is her quote. Should you still choose to do that, I will notify some of my acquaintances on the board that it is coming. A person is not afraid when they know they have not done anything except try to help both buyer and seller to the best of their ability. So to me, that sounds like she could have possibly notified any of you. So I wanted to ask if anyone needs
Mr. Chair,
to
I'd like to take number 44 off.
recuse
the consent
themselves.
Okay. Okay. So 44 is off.
I think in Robin's 1 through 30, we're only taking off number 1, correct?
Correct.
So then Erica will read 2 through 30 into the record.
Case
Will you
numbers.
just read the case number?
I'm so sorry. It was not 44. That was the one that Mr. Wood had a question about. I'm sorry about that. It's number 58.
So 44 is still on the consent
Yes.
agenda. Yep. Okay.
So 58, same exact thing that I just said.
Yes. Okay. So, are we ready to read numbers now?
Are you sure? Erica, are you reading my numbers in?
Robin, she's going to read your numbers, and the only one they're taking off on yours is number 1.
I got that.
Okay.
Okay. Ms. Smith, could you read numbers 2 through 30?
Number 2, 2017-046881. Number 3, 2017-046941. Number 4, 2017-046981.
Hey, Robin, can you mute your phone?
Yes, I'll try to mute that.
Thanks.
Number 5, 2017-047701. Number 6, 2017-048381. Number 7, 2017-048401. Number 8, 2017-048901. Number 9, 2017-048921. Number 10, 2017-049201. Number 11, 2017-050161. Number 12, 2017-050201. Number 13, 2017-050031. Number 14, 2017-050101. Number 15, 2017-050621. Number 16, 2017-050641. Number 17, 2017-050661. 18, 2017-050681. 19, 2017-050861. 20, 2017-051111. 21, 2017-051451. 22, 2017-051471. 23, 2017-052801. 24, 2017-053-221, 25, 2017-053-261, 26, 2017-053-511, 27, 2017-053-371, 28, 2017-054-301, 29, 2017-054-321, 30, 2017-052-921,
And can you get 31 through 46?
31, 2017-046-211, 32, 2017-046-451, 33, 2017-046-761, 34, 2017-046-801, 35, 2017-046-921, 36, 2017-048-441, 37, 2017-048-511, 38, 2017-048-881, 39, 2017-048-941, 40, 2017-049-671, 41, 2017-049-761, 42, 2017-049-441, 43, 2017-049-461, 44, 2017-049-631, 45, 2017-050-841, and 46, 2017-050-901.
50, please.
2050 is 2017-051-211.
54 through 57.
54, 2017-051-251. 55, 2017-052-111. 56, 2017-052-171. 57, 2017-052-401.
59 through 62.
59, 2017-053-881. 60, 2017-053-901. 61, 2017-054-391. 62, 2017-054-441.
Thank you, Ms. Smith.
You're welcome.
Drink some water and take a break there. Okay, those are all the matters that remain on the consent agenda, and the recommendation on all of those is to dismiss. Is there a motion to approve the dismissal of those matters on the consent agenda?
Motion to approve.
Motion by Mr. Horn, seconded by Ms. Hills, to dismiss the matters that are still on the consent agenda. Is there any discussion? All those in favor of the motion vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Okay, let's go back to consent agenda item number 1. Ms. Ryan.
Yes.
Tell us about number 1.
Okay. Well, in this particular complaint, would you like me to read it into the record?
Well, I had the question.
Mr. Wood has a question.
Let me start with the question.
All right.
I'm reading the first part, and it says complainant is the buyer, and respondent is buyer's agent. And then later on, it says, like the third from the end paragraph, it says respondent states when respondent listed the property. So that would make the respondent the listing agent.
Let me look up that file. I think it was crud. I think they were dual agent and or. Let me look it up, okay?
Okay.
Just make it easier. What's the name here? And that may be a mistake on my part that I didn't catch, but let me just look it up. Okay. I'm sorry. It's time consuming at home because I have to go through 4 programs in order to get up one. So I apologize. I believe she was the facilitator. I mean, he or she was the facilitator.
I'm sorry.
I'm sorry, what did you say, Ms. Ryan? He was facilitator?
I handled him.
Do you have the confirmation of agency?
Hold on just a moment. Shoot. I'm looking up the response right now. Oh, for crying out loud. This is very awkward, and I do apologize for it. Someday we're going to be really contemporary with these things, but we're not quite there yet.
Ms. Ryan, would it be better if we continued item number 1 to our legal report next month?
No, I can get it. I have no problem getting the information. It's there. It's just a problem of accessing it while I'm on the telephone on the computer. So how about if you come back to that one and I'll look it up in the meantime?
Okay, that's fine. Sarah, was Robin going to do the matters that were hers on the regular legal report? Or?
Robin is going to be there for answering questions. Erica is going to read them all in front of you all.
Okay. Why don't we go to the other items that we had from the consent agenda that were Ms. Smith's items while Ms. Ryan is looking up the information in response to Mr. Wood's question. So, Ms. Smith, let's go to numbers 47 and 48 and 49, I believe. Let's see. '47 and 48. I know Commissioner Bloom and Commissioner Wood had questions, I think, about 47 and 48. Gentlemen, would you prefer to have this read in, or do you just want to ask your specific question?
I just have a question.
Okay, why don't you ask your question, Commissioner Bloom?
Okay, Erica, in the contract, did it give the respondent the right to terminate the contract following inspection?
1 second.
You can answer that for us if you can tell us if it was on the TAR copyright form.
That for you?
It was probably done in 2017. I think there was still TAR back then.
Yes, it is on a TAR form.
Arguing about the distribution of the earnest money, and doesn't the owner of the property right after the inspection to withdraw from the contract and get the earnest money refunded?
Well, I believe you have the ability to get out of the contract after the inspection for certain reasons. I think the argument here is that the complainant's saying that there's safety hazards, but the inspection did not say that there were safety hazards. That's just her opinion. So it was the respondent's opinion that, or I guess it was the seller's opinion that there were also no safety hazards, and the seller would not let them out of the contract because the home inspection didn't refer to anything that was a safety hazard. The complainant mentions that she's handicapped and there's steps, and The complainant is the wife, and then the husband. They were completely divided the whole time. One of them wanted to go through with it, one of them didn't. In my opinion, there was no reason for them to be able to get out of the contract after the inspection.
Any other way to get in and out of the house other than the steps?
Yes, the steps were only, the complainant only mentioned the steps that she would have to use to let her dog out in the back.
Get out the front with her wheelchair, okay?
I don't believe she's in a wheelchair.
Oh, okay. I thought it said she's in a wheelchair.
No, she mentions that she's disabled, but she doesn't go into detail.
Okay.
But according to state law, a buyer has a latitude to also do their own inspection. So it could be something that they don't like about the property that's not on the inspection report.
Right. And the complainant's husband, they were coming from out of state. The complainant's husband viewed the property and didn't find that there were any issues when he looked at it as well. So,
is this matter in litigation? Because there's a sentence that refers to the respondent is doing what the judge orders to do with the money and will not be released until the judge orders.
So yes, the earnest money was
interpleaded.
Yes, interpleaded.
Okay.
Yes.
Okay.
Oh, could we set this up for litigation monitoring?
If that's what the commission would like to do.
Well, the difference here, though, is the agent's not under the litigation. It's between the buyers and sellers.
Yes. The agent, I think, is just going to release the money according to whatever the judge decides. It was my opinion that the respondent didn't violate any laws or statutes and really isn't involved in this dispute.
Hopefully, if it's an interplead, if it's interplayed, that money's already in the court's hands.
Yes.
Is that your belief?
Yes.
Okay.
Yes.
So
That last statement, respondent feels that the complainant doesn't understand that the earnest money has to be dispersed after arbitration, despite respondent's effort to explain. Respondent is doing exactly what the judge orders him to do, as the money is in escrow and will not be released.
Yes, the respondent did say that the money was in escrow, but at the same time, I know that it's been interpleaded. So
arbitration.
It could be that maybe an order was entered that has the money still sitting in an escrow account, but it's subject to whatever the judge tells them to do with the money.
Yeah, that's what I mean. I would assume
I've done
that
before.
because all the respondent has said is that I have no opinion on this. I'm just going to do exactly what the judge ordered. So I would assume if it was in the wrong place, it would have been brought up by the judge by now. You know, I wouldn't think that is an issue to worry about.
Anybody want to make a motion
So do we
about
come
47?
do we come to the conclusion we think it's in interpleader right now, or do we not? Or are we not sure?
I know. Yeah, I mean, it could have been resolved by now, but at the time the complaint and the response came in, it was absolutely in. I didn't realize that you actually do arbitration and do an interpleader that way, but I know that's the word the respondent used, and
I got the feeling when I read this, to me, the respondent was kind of using some terms that didn't go together, like the arbitration, and that didn't go together. And I got the feeling, too, that they had gone ahead and made a decision on what should happen to the earnest money based upon the fact that they felt the buyer was wanting out of the contract. And, you know, that the buyer they'd already made up their mind before they did the inspection. Well, but that's in the contract, that they can get out for any reason that they, you know, that's a real reason, and that's not cosmetic.
Right.
I mean, you know, I've seen people get out because the doors stick, you know, and sellers go, I'll fix that. Nope, doors stick, I'm out. And
So-
they have that opportunity to do that.
yeah, the respondent did make that comment, but I don't believe the respondent acted on I don't think obviously the money never left escrow. So
Still makes me uncomfortable, but I don't know that there's anything in this book that, so I'm going to make the motion to dismiss.
We have a motion by Commissioner Wood to dismiss. Is there a second? Seconded by Commissioner Horn. Discussion. This is number 47. All those in favor of dismissing number 47, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Ms. Smith, do you need to read into the record the case number for number 47?
yes, 47, 2017, 050321.
Okay. Do you mind reading the case number now for 48?
48, 2017, 050361. And this matter involves the principal broker for the affiliate broker.
Move to dismiss.
Motion by Commissioner Wood, seconded by Commissioner Taylor to dismiss number 48. Discussion? All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Do you mind reading number 49 now, please? That number.
49, 2017, 051191.
Commissioner Bloom, did you have a question about 49? Or did anybody have a question about 49?
We skip that right now.
Okay. We will come back to 49. Let's move on now to 51. Ms. Smith, do you mind reading that number, please?
51, 2017, 051271.
All right. Commissioner Hills, did you have some questions about number 51?
Uh-huh. In the second sentence, the complainant states that that a repair replacement agreement was signed by all parties on June 30th, 2017. And that would be a TAR form. And I just need to know if that was true. And then on the next page, about midway down, the respondent sort of refers to it after the respondent is going into great detail explaining how he has taken such care of this client, but never comes out and says that. Then when we go to the case number 53, where it's the other agent, the seller's agent says one was never signed. So I guess my question is, was there one signed or not?
So the complainant made the statement that one was signed. And the only copy that I have was provided by the affiliate broker in number 53. And it is not signed by the buyer. It's signed by the seller only. So I think all of the respondents here make the point that it's not even enforceable because it wasn't signed by all parties. Even the complainant thinks it was, but hasn't been able to produce that. And I think made that statement to show that they could have not done any of it, but they were trying to move forward in good faith and close the deal. So the buyer or the seller technically didn't have to repair any of those and went and did, more than they needed to. And but from the copy, the only copy that I have, it only has the seller's signature on it.
Because that's sort of how it looks to me. So on the page 2 of case 51, the respondent numbers it, spells it out, and pleads the case in such detail and says how detailed he or she is in doing everything. If that one thing had been done, I don't think we would have this case. And that he or she fails to say, he or she says, all parties on the buy-in spoke candidly about the condition of the house, which led to a very specific and detailed inspection contingency release notification by respondent. This agreement requires the seller to make certain repairs and provide invoices from licensed professionals 2 days prior before closing, as complainant stated in his complaint. So if I were the respondent, if I were the agent trying to defend my case, I certainly would have said we had this paper.
Right. And that respondent never brought it up. So I didn't want to put it in this summary, even though it was brought up by the seller's agent.
I don't think this agent, so I think the agent didn't use reasonable care.
Commissioner Hills, is there a motion that you'd like to make?
For failure to use reasonable care, and I'd have to find it.
6213-403.
By failing to have his client sign the repair amendment. Okay.
What is the penalty that you would like to recommend for your motion?
What the complainant says, how he was damaged. Let me see. $500.
All right, there's a motion by Commissioner Hills to impose a $500 civil penalty, seconded by Commissioner Horn. This is for violation of 6213-403, failure to use reasonable care, for item number 51. Any further discussion?
My question is, I guess it's more of an Erica question. Do you think that both sides didn't sign it because both sides didn't agree to it? Or maybe just proposed?
I think both sides did agree to it, and it somehow was overlooked. I don't think there was. I feel from everything I've read, all the parties truly acted in good faith and did everything they could to make this transaction work. And I don't even know if this affiliate broker realized it, obviously, or maybe they didn't bring it up because it looks bad on them. But I feel like in everything I read, both parties knew what was to be repaired. They all agreed to it. And the seller didn't really follow through in the end, and then offered a monetary amount to, I guess, for the buyer to be able to fix whatever the seller didn't finish.
All right, any other questions?
So then you feel the complainant's complaint then is what?
Like, what is the complainant's issue? The complainant feels like the respondent didn't represent him to the best of his ability, I think. Didn't represent his best interest at closing because the complainant alleges that the respondent didn't say you don't have to close right now. You can delay it. But not only his agent, but the seller's agent And both principal brokers have all said that that is not true. That the respondent did say, or the respondent's assistant did say, not assistant, licensed agent that was there, did say you don't have to close. Here's your options. And the complainant wanted to go through with it and was fine with the $1,200.
I withdraw.
All right, the motion has been withdrawn, so we need a new motion. Does anybody want to make a motion about the disposition?
Dismiss.
Second.
Motion by Commissioner Taylor, seconded by Commissioner Hills to dismiss. Discussion or questions? Hearing none, let's vote. All those in favor, vote aye.
Aye.
All opposed, vote no.
I'm ready for 49.
Clarify that was.
Okay, that motion carries unanimously. We'll get back to 49 in just a second. Let's go ahead. I think 52 and 53 are related to 51. Is that right?
And a motion to,
Let's let her read.
Oh, see.
Will you read in the numbers for 52 and 53?
52, 2017-051-301. 53, 2017-051-171.
motion to dismiss.
We have a motion by Commissioner Hill, seconded by Commissioner Horn to dismiss 52 and 53. Discussion. All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Okay, we're going to go back to number 49 now. Do we need to read that number again, or are we good? I think you read it once already. Okay, Commissioner Bloom, you had a question.
It's just a question, actually, for Erica. In the second paragraph, it says that there was an exclusive buyer's representation agreement showing respondent was appointed designated agent for complainant as a seller and buyer. Or should I go back and pick up that they did both and we just missed a comma? A signed listing agreement, which would have been for the designated buyer's representation for the seller. I mean, there's two properties. They're buying one and selling another.
Right, the same person is using the complainant was using the agent to buy a home and then sell her home.
But the buyer's exclusive representation agreement does not include an opportunity to be a designated agent.
Okay, so.
Asking if there should be a comma there because it
Yes.
could be that they were.
But I can pull it up, the representation agreement, if you'd like me to.
If that's two agreements, I'm fine.
Yeah, I mean, I made sure that all the documents that needed to be signed were to show that the respondent was properly the agent for the client as a buyer and then as a seller.
Okay, I'm fine.
So I worded it.
Commissioner Bloom, are you satisfied with that
Yes, sir.
information?
Yes, sir.
Do you want to make a motion to
I
dismiss?
do. I would move to dismiss.
Okay. We have a motion by Commissioner Bloom, seconded by Commissioner Wood to dismiss number 49. Discussion? All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. All right. Could you read in number 58, Ms. Smith, just the number, please?
And also, 2017-053-141.
Okay. And there was an email that you read to us earlier, and so there was a question whether any commissioner has any knowledge of this complaint. And so that's a question I'm posing now to the commission. Hearing none, we will assume that no one has any knowledge. And so, Commissioner Hills, you had a question about this matter. Is that correct?
Yes. So the binder, was it put into the company's escrow at the beginning of the purchase and sale agreement? Or did it
The
come
binder?
late? Oh, the $90,000.
Was it put into the escrow account? Is that what you're asking?
Yes.
As opposed to.
What was it at the beginning? Was it part of the agreement at the beginning, or did it materialize later?
I
was a little
believe
confused
I
with
believe
that.
the complainant made an offer, and it wasn't accepted, and he tried to, or there was an issue with the seller that there was a reason why the seller couldn't accept that offer because something maybe she was buying, and so he wanted to sweeten the offer by offering this 90,000 as this. It's very confusing to me. I've never heard of this before, but I think then the seller accepted it once he sweetened that offer by doing that. So I would say,
But once they put it in writing, it was there at the beginning of the
Yes.
written.
Oh, yes, yes,
Okay,
yes.
that's my question.
Yes.
So it was there at the beginning when it was written. So was it stated that 90,000 was to go anywhere else, or well, and was it a TAR form? Because a TAR, it says where it's to sit. It's sitting.
So while they're looking that up, I got the impression that 90,000 showed up near the end of the contract.
Well, I did too. I was confused
Not at the
if
start.
it was at the beginning
It's an
of the
inducement.
agreement, or if it came into it
It appeared to me
later after the agreement had been. That was I was confused as to
It
when
looked to
it
me
was.
like the contract's about to expire. The guy says, "I'll loan you 90,000 on a short-term basis if you'll extend the contract."
So
That's when I think it
oh,
showed up.
you're right. That is exactly what happened. So
But
I guess
the
that
whole
would make it
discussion
not at
was
the
about
beginning.
them charging them rent, wasn't it? It's really not the 90,000. It's the rent that they're arguing
that's
about.
that's the issue the complainant has, is that the 90,000 minus that amount owed for rent. That's the issue the complainant has, is that he didn't get all of that back.
So who was holding the 90?
The respondent in the respondent's escrow account. It is a TAR form.
So on the form at the beginning, it did not say 90,000. Then? How do you use, it says to use, the respondent might use for a short time to loan the seller to avoid. So how do you use escrow money as a loan?
And that's what the respondent, it's confusing to me because the respondent did it, but then the respondent makes it seem like she knows that it wasn't the right thing to do and knew that it couldn't leave escrow. So she makes that statement, and that the title company confirmed that it couldn't be used as anything other than earnest money. I don't think it ever was, or even was attempted to be.
We don't think it left the escrow.
Not that I know of. Until it was given back to the complainant, minus that money that was owed for his early occupation.
I started off reading it, and I focused on the 90,000, but at the end, I really thought my focus was on the rent, and then that was really an argument between the buyer and the seller if they were going to charge them rent or not. It's kind of
That is definitely in the contract.
Yeah.
The rent, the rate.
I thought maybe that maybe the buyer felt that since he was such a nice guy, loaning them the 90,000, that the rent was going to go away or something, and the seller did not let the rent go away.
Right, like
that's
seller
what I
would-
thought the argument was between those two.
That's exactly what I feel the argument is as well. And the seller at closing said, "I'm not signing this unless I get this rent." So the title company and the respondent decided to close it, that it was okay to take that from the 90,000.
Buyer went ahead and signed it, saying it was okay, or they would have never closed.
Right.
I mean, they went ahead and agreed to it at the closing table, and now after the closing table, they want to try to get it back.
Exactly. And it's the respondent's opinion that the complainant knew he wasn't going to honor it all along and did this as kind of a scheme. Was way ahead of the game somehow and knew what he was doing when he did this. Because he was there for 63 days or something like that. Or maybe 40-something days, and it was $63.33 a day. So if that adds, that's quite a bit of money.
It just concerns me that through the story that the respondent, and I don't know if it's on the purchase and sale agreement, that escrow money was going to be, and maybe it's identified that money was going to be used as some sort of loan, and it wasn't going to be identified as in an escrow account. So I agree that the end result was that the beef, the argument is over the 2719, but to think you would be bartering with $90,000 escrow.
Well, I think that was the buyer. The buyer was the one that suggested that to what to do with that $90,000. Yeah, I mean, so I don't think anybody's having any discussion that there was any hanky panky over the 90,000. So
brought that up. Here's how I read it. So we have a seller who's got a house he or she wants to buy. The buyer of her current house wants an extension on the contract. Well, that leaves the seller short money to buy the house she wants. So the buyer comes along and says, "I'll loan you $90,000 to complete the purchase of the home, as long as I can close later on the home I want to buy." Mm-hmm. Well, that $90,000 never went anywhere that I can tell. So I'm trying to understand how this works. So the buyer has to have cash to close, but the cash never came out of the escrow account. So I don't know if she used that to show that she had the escrow account in her hand, so a lender would say, "Okay, you've already got $90,000," when in fact she never had it. I'm trying to figure out what looks like some sort of funny deal.
Mm-hmm. It seemed very funny to me, but I truly believe that if everything was the complainant's idea and he planned it this way, thinking that he could get out of paying this rent somehow, thinking he'd get all that $90,000 back, and then there'd be a dispute about him having to pay the rent money, and it wouldn't have come out of anything. He wouldn't have had to pay it. He could have just, been taken to court. But I don't think it was in his plan that the title company and the respondent and the seller would all refuse to close without getting that money.
In fact, I would think, follow my logic, the seller should have that $90,000. It shouldn't be in the escrow account if it was a loan necessary to buy the house that the seller bought.
Right. Yeah, that was very confusing to me. But I didn't, I tried to find something that showed me the respondent was doing anything shady, and I just couldn't. I don't even think the respondent understood why the complainant wanted to do it, but felt okay putting money in an escrow account, calling it earnest money, and not touching it.
Anybody provide a document that talked about that $90,000? Like an escrow agreement or how it's to be dispersed?
Yeah. Because you can do anything as long as you write down what you're doing. I mean, we can do.
To double check that, no, there's not anything that is an explanation of it or.
Sloppy work on my part, but I'm not sure that's.
I mean, I agreed with that. I wasn't sure if it was a violation or not, honestly.
I'm all right. Motion to dismiss.
Second.
We have a motion by Commissioner Hill, seconded by Commissioner Wood to dismiss. Any further discussion? If not, let's vote. All those in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Let's go back to number 1. And Ms. Smith, if you don't mind, could you read in the number for number 1, please?
Number 1 is 2017-046821.
Okay. Commissioner Wood was asking Ms. Ryan a question about a document. Ms. Ryan, have you been able to locate that document?
Yes, and again, can you hear me?
We can hear you.
Okay. Again, I apologize. I am not as technically efficient as I should be.
You're fine. Go ahead.
Okay. This is an error on my part. Respondent was the seller's agent. That's totally an error on my part.
The complainant is the seller and the respondent is the seller's agent.
No, complainant is the buyer and respondent is the seller's agent.
Okay. Mr. Wood, do you have other questions?
Did the buyer have a buyer's agent?
No.
Okay.
The buyer was not represented.
Okay.
And it says so in the document.
Okay, got it. Really, the point of contention for the buyer was that they felt that the listing agent should have told them more about the property.
They felt that somehow the listing agent knew more than the listing agent knew, even though it wasn't the listing agent's property, and that, yes, indeed, that somehow they knew more and should have revealed it. Yes, that was the complaint from the complainant. And the fact that the respondent posted on the website, business website, a review that was not very flattering.
Any control over that? I think the responsibility for disclosure is on the seller.
It is.
Okay. I'm going to make the motion to dismiss.
All right, we have a motion by Commissioner Wood, second by Commissioner Taylor to dismiss number 1. Any further discussion or questions? Let's vote. All those in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. And that concludes the consent agenda items. And so at this time we will move on to the January legal report. I understand that Ms. Smith, will you be sort of initially handling Ms. Ryan's cases, but we have Ms. Ryan available if there are specific questions. Is that correct?
Yes, I was going to read them.
Okay.
And then, yes, if you have questions, she'll address.
If I might interrupt for just a moment, I just wanted to assure the commission there is indeed a hearing next month. This hearing was scheduled in November and continued at the request of the respondent's attorney. So, yes, there is a hearing next month.
Okay, thank you. All right, let's proceed with number 1.
2017-049841. Complainant is buyer and respondent is buyer's agent and one of the owners of property. Complainant states complainant was given a full year warranty on the new home purchased. Within that year, complainant states an inspector was hired and found construction defects. Complainant contacted builder, but builder would only agree to do simple work and none of the work for the infrastructure. Complainant states builder has not checked on the issues. Complainant states respondent hired contractor to build house and that respondent was the agent and original owner of the property in question. Complainant did not get inspector at time of closing, but states that this does not affect warranty. Respondent states respondent was complainant's agent in transaction and that complainant waived home inspection and accepted property as is. Respondent states builder provided a 1-year home warranty. Respondent and complainant signed an exclusive buyer representation agreement on July 1st. In confirmation of agency status, respondent is checked as disclosed dual agent for both parties, signed on July 1st. New construction and sale agreement signed June 17th. This is a construction matter, but the documents signed show respondent being designated agent for complainant after purchase agreement signed, and later show respondent as dual agent. And the recommendation is a $1,000 civil penalty for violation of TCA 62-13-31220, improper conduct.
Mr. Wood.
Okay, so if I got this right, so the agent is a dual agent, but they're saying they represent the buyer and they represent the seller, and the seller is also themselves.
Yes, and the initial transaction involved the respondent being the buyer's agent, period, and then later designated as an agent for the complainant on the purchase agreement, on the sale agreement, and then later as a dual agent. But at all times, the respondent was the initial owner of the property.
So are you thinking that when you kind of were given what the different positions was of the, I don't know what to call the person, the respondent, did they change their status during the course of it, or did they mark different things on different forms?
It would appear to me that they marked different things on different forms, but the most important thing is that for the person that was buying this, would have been very confusing, because remember, the respondent is the initial owner of the property who hired the contractor and signed on initially as being that buyer's agent. And then that was a new construction and the sale agreement, which was signed on June 17th. And then later on, signed as dual agent on July 1st. I don't see that this change of status was really actually relayed to the complainant in this matter, who had a right to believe that this person was representing them.
Hills.
And to me, with the sloppiness of the agency, the self-dealing, I mean, I think it could have been very confusing when you're dealing with a contractor and an agent brings this buyer to a builder. That buyer could have been confused as to who the seller actually was. So did they disclose any self-dealing?
Like a personal interest disclosure?
Well, yes, they did reveal that they owned the property originally. Yes, the respondent did reveal that he or she was the owner of the property in question, and that person, the respondent, did hire the contractor to build the home in question as well.
All right.
Mr. Reese.
Miss Ryan, I hope you're healing okay. Is that a true statement?
That I'm healing okay?
Yeah.
I'm healed. I'm just, let me tell you something. I am stuck in a wheelchair because I'm not allowed to use any to walk, which means I can't drive, which means I'm at the mercy of my poor husband, who may or may not decide to take me someplace. And I'm stuck at home, and for all of you who've ever worked from home, for me, what I see working from home is dirty dishes and my father and all that jazz.
All right, okay, so you answered my question. Now I want to get back to this case.
All right.
Was any agency disclosure signed prior to the offer being written? It looks to me like your dates are all after the contract was signed.
That's right. The contract, I don't think, let me look, but I'm not certain that one was included, but let me check on the date, because this troubled me in the dates of all the documents. And the relays to the respondent. Let me just find the file. Sorry, this is going to take a moment, because when I click on a file, I have to look at you guys first before the file will come up. And hi, you all look pretty good today.
Robin, we've got the computer right here. We can probably find it quicker. What are you looking for?
I'm looking to see if there was the original document signed.
Purchase and sale agreement? Or
before that.
the new
Agency
disclosure
Okay.
form.
We're scrolling through right now. Okay, so we've got an exclusive buyer representation agreement.
What date?
Keep going. So it was signed, that was signed on July 1st, 2016 by both parties.
So the narrative says that, and the narrative also says that a disclosed dual agency disclosure was signed on that same date.
Confirmation.
Okay. So it's just a box. It might have been mischecked. Okay.
So, and that was a confirmation, just disclosure.
The new construction contract was signed on June 17th, and that new construction, it is listed as she is listed as the buyer. As the seller, and the listing agency is respondent. The selling agency is respondent. The exclusive representation agreement was signed again after that on July 1st.
Oh, I guess my only point is those disclosures are to be made prior to a purchase offer being written, not 2 weeks afterwards.
That was my concern.
Robin, is it possible to be a disclosed dual agent on property that you own?
Well, yes, I think so, because
How can I represent a buyer on property that I own?
Well, you're the bot. You can. I think you can if it's clean and clear up front. You can represent the buyer as a facilitator.
Oh yeah, as a facilitator, I can do that.
Yes. But you're not representing the buyer.
Yeah, right. But it's impossible for me to disavow my own interest and be declared dual agent.
I don't disagree with that. And again, that's one of the problems I have with this.
I'm thinking this is a prime candidate. I think there's other things, but this person's going to need about 4 hours of contracts and about 4 hours of agency to kind of help. I think they're confused. Is what they are.
I agree.
All right, so is there a motion?
Bobby has it.
Mr. Wood. I think I'd like to hear what other things as far as, I think I got the education part covered, but I think there's some civil penalty stuff here too.
Recommendation of a $1,000 civil penalty.
Okay, let me start it with the motion, and then if anybody wants to amend it, we'll do it. How about we'll make a $1,000 civil penalty for improper conduct, and also part of that is that we're going to require additional education, a 4-hour contracts class, a minimum 4-hour contracts class, and a minimum 4-hour agency class, and none of those classes will be considered part of their regular CE.
Second.
All right, we have a motion by Commissioner Woods, seconded by Commissioner Bloom for a $1,000 civil penalty, 4 hours of additional education above requirements on the subject of contracts, and 4 hours of additional education above requirements on the subject of agency. Discussion? Commissioner Taylor.
Frame in that and within 180
days.
Yeah.
Education to be completed within 180 days of the execution of the consent order. All right, any other discussion? Commissioner Horn.
$1,000 penalty for what? What did he do? Well, that's kind of he didn't do his job.
Well, he didn't get the form signed. He didn't.
Proper
He didn't
conduct.
disclose. He didn't.
Commissioner Horn, I would put it like this. I say he lied, and I think he misled people. He's sitting here saying, "Hey, I'm gonna be on your side. I'm gonna negotiate on your behalf." And how can you really do that? And Commissioner Bloom's pointing that out. How can you tell somebody, I'm going to look out for your best interest against that seller? Oh, by the way, I'm the seller, so I'm really not going to look out for my best interest. I'm going to look out for yours. I don't think that's realistic.
Back to the old concept again, buyer beware. And if a person want to sell me or sardine can, and I know it's foolishness. I just can't see how he made a mistake. He put a bogus deal before the person and he bought it. So what we're saying, we're going to protect the people that's not so smart from those that's real smart. Is that the idea?
Whenever the people who are real smart tell the non-smart person that they're acting on their behalf, then I think yes.
That's every day.
But they're a professional licensee of the state of Tennessee.
License to do it, right?
Protecting the cell. Our job is to protect the public.
I just wanted to make that point. I withdraw.
I understand. All right, you've heard the motion. Any additional discussion? Let's go ahead and vote. All those in favor vote aye.
Aye.
All opposed vote no.
I'm thinking this over. Give me a minute. I believe I need to abstain.
All right. Motion carries on a 7 yes, 1 abstention basis with Commissioner Horn abstaining. Let's go on to number 2. Ms. Smith.
2017-049861. The respondent is the principal broker to the above affiliate and states that the affiliate represented the buyer in the transaction. Respondent states buyer declined a home inspection and accepted the property condition as is before closing. Respondent does not address the conflict between representing only buyer and the fact affiliate was seller as well. Respondent does not address dual agent versus designated agent documents. The recommendation is a $1,000 civil penalty for violation of TCA 62-13-31215 for failure to supervise.
By the fact that the broker didn't address those things leads me to believe the broker may be confused on it too. And so for that reason, I'd like to make the motion that we offer a $1,000 civil penalty for violation of failure to supervise, but also require them to take a minimum of 4 hours class in contracts and minimum of 4-hour class on agency to be done within 180 days. That does not count towards their required education.
All right, you've heard the motion by Commissioner Wood, seconded by Commissioner Taylor for a $1,000 civil penalty plus 4 hours of additional education above requirements in the subject of contracts and 4 hours of additional education above requirements on the subject of agency, all to be completed within 180 days of the execution of the consent order. Discussion? Mr. Horn.
That is a person that's required to training, which I feel like we're in our rights, and the training is definitely needed. But how can we say that it won't count against his continued education? Education is education, no matter how you get it, whether you force fed or you volunteer. I mean, if he's got that requirement, I think he needs to be able to show it.
If we say, okay, you take it in this, and then they get to count it toward their 16 hours, it really isn't any kind of deterrent. And I think the intention here is try to make this a deterrent so they don't come back and do this again. I mean, they have there's a wide range of topics that they can take continuing education on. And I'm sure they've had these topics in the past, but it doesn't appear that it took.
Minimum.
Yeah. He gets credit for the education. He just.
I think Bobby said what I was going to say. To me, this is core stuff he should have already learned, and if he hadn't already learned it, then let's go back and do it again, which is kind of the way I see this condition put on this civil penalty.
Courses and still get credit for it, but I think if I made an A and somebody said, "Hey, you need to take that course," hard time making that stick when I've done what was required of me.
In a disciplinary situation, we have the ability to require something more. Like Commissioner Wood said, it didn't take the first time. All right. In the absence of any additional discussion, we'll go ahead and vote. All those in favor vote aye.
Aye.
All opposed vote no. All right. Motion carries unanimously. Number 3, please.
2017-052-071. Complainant states respondent is acting as property manager, doing leases and collecting rents in 2 mobile parks in one town and one in another. Included was a form letter from respondent stating that under new management and recipient should schedule an appointment regarding a current lease and also threatens eviction. Respondent states that company, through individual, is managing mobile home parks and another property with homes for owners of property, but not selling real estate. Respondent states that respondent collects rent, manages the transportation company in moving the homes, manages the maintenance, and leases and rents homes for owner. Respondent states that owners switched to respondent in 2017 and properties were managed similarly by another prior to the switch. The recommendation is a $3,000 civil penalty and $1,000 for each of the 3 properties mentioned for unlicensed practice.
All right. Any questions or motion?
Move to accept council's recommendation.
All right, motion by Commissioner Wood, seconded by Commissioner Taylor for a $3,000 civil penalty. Any discussion? All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Number 4, please.
2017-052-521. Complainant states respondent submitted a property management contract to manage rental of complainant's home. Complainant states respondent allowed 12 occupants, allowed tenant to move 2 sheds, and collected only 2 months' rent before tenants moved out. Respondent addressed the issues of complainant. Respondent also states respondent was hired to rent complainant's home to tenants and states respondent has a business license but is not a real estate licensee. Respondent states respondent informed complainant of this in negotiating the contract. The recommendation is a $1,000 civil penalty for unlicensed practice.
Second.
We have a motion by Commissioner Hill, seconded by Commissioner Wood for a $1,000 civil penalty. Discussion? All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Number 5, please.
2017-053-631. Complainant represents buyer and respondent represented seller. Complainant states an offer was presented and accepted on July 30th, but that when the offer was presented, there was not any response for 4 days. During this time, complainant asked respondent if there were other offers and was assured that there were not. On August 5th, complainant states respondent called to say that respondent was in a pickle as respondent had forgotten an offer that had been accepted that respondent had not disclosed. Complainant states respondent asked if there was something that could work, but complainant stated buyers expected to purchase the home. Later that day, complainant states respondent texted stating respondent may have found an out on other contract, but next day respondent told complainant that E&O provider told respondent that first offer must be the offer. Complainant told respondent that buyers expected to close. After discussion with buyers, complainant decided to move on to another sale. Respondent states that on June 30th, property had contract contingent on a 3-bedroom soil evaluation. After the evaluation, it was determined that the property was a 1 or 2 bedroom at best, but that an actual perk test would be needed. The cost of getting that work done was relayed to sellers who were not willing to spend the amount quoted. On July 22nd, an offer was presented to purchase this property together with an adjoining 9 acres and was set to close, but only if buyers could buy both tracts and contingent on termination of the previous contract. First buyer then called to inform respondent that soil evaluator said if property was bush hogged and actual perk was completed, the property would likely go for a 2 or 3 bedroom. Agent called to state that if perk test was not completed, a suit could follow as buyer wanted the land. Respondent states that at this point, respondent assumed the second contract would terminate as both tracts would not be available as provided in the contract. Respondent then received contract from complainant for property not including the first tract and concedes that this contract should have been a backup contract. The original property was bush hogged and it was likely still to be a 1 to 2 bedroom, which would require a perk test. Agent for first buyer then called to say buyers were walking and requested return of earnest money. Respondent then called complainant, and complainant told respondent that buyers were going through with the contract. The next day, respondent again called complainant and told complainant that respondent had to contact E&O carrier unless buyers were willing to be the backup. Respondent states that during this process, respondent was dealing with mother's Alzheimer's, father's stage 4 colon, lung, and liver cancer, and that respondent and family were out of town for a couple of days when receiving the contract from complainant. While there were many factors involved in these potential sales, respondent admits that the proposed contract from complainant should have been a backup contract considering the issues involving the 2 land tracts. Respondent also should have revealed pending contracts related to the entire property. The recommendation is a $1,000 civil penalty for violation of TCA 62-13-4031 for not exercising reasonable skill and care, and a $1,000 civil penalty for violation of TCA 62-13-4032 for not disclosing adverse facts known.
Motion to accept council's recommendation.
Second.
There's a motion by Commissioner Taylor, seconded by Commissioner Hills, to accept the recommendation of a total $2,000 civil penalty. Discussion?
Yes, I'd like to add, if permitted, to take a contract course.
Yes.
4 hours within
Yes.
180 days?
Right.
Okay. Is there any objection from Commissioner Taylor or Commissioner Hills to amending the motion? Okay. Commissioner Wood, did you have something else to add?
I was going to say the exact same Commissioner Bloom did.
Okay. All right, any additional discussion? Let me restate the motion. The motion is for a $2,000 civil penalty plus completion of an additional 4 hours of continuing education in contracts above the existing requirements to be completed within 180 days of execution of the consent order. Let's vote. All those in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Number 6, please.
Number 6, 2017-053941. Complainant is the seller and respondent is seller's agent. Complainant states that complainant listed 2 4-acre lots with respondent with a 12-month listing. This listing was 4 years ago. Since the listing, complainant states complainant has not heard from respondent. Complainant recently contacted another licensee who in searching for comps found properties still listed on the MLS showing 900 days on the market. Complainant states that the properties were combined into one listing which was never approved by complainant. Complainant contacted respondent who stated that when respondent receives notification of expiration of a listing, respondent does not let the listing expire but extends the listing expiration date for an additional year. Complainant states complainant never agreed to this nor was made aware of this. Complainant left a message for principal broker, but respondent's spouse called complainant to state principal broker was ill, that the listing issue was no big deal, and that respondent took out the listing. Complainant told spouse complainant was concerned that the website show properties listed for 900 days, and spouse suggested complainant call the listing sites and ask listing sites to remove that information. Complainant suggested that respondent buy the lots and then respondent could deal with the issue in reselling the lots, which was rejected by the spouse.
Erica, can I interrupt you 1 second?
Sure.
Is the spouse of the respondent, is that person an agent also?
Robin, do you know that? Robin? Are you there, Robin? I'll look.
Well, go ahead and finish on, and
If you'll pull
maybe
it up.
Robin can look it up for us.
And do you understand the question? See if the respondents.
It's just mentioned in there a couple times, I think, about the respondent's spouse was in this conversation. I'm just...
Right. Okay. Respondent states respondent had no written extension for listing of complainant's properties and admits respondent should have secured the same. Respondent states complainant listed another property with respondent in 2015 and that property sold. Respondent recalls speaking with complainant in early 2016 and that complainant gave verbal agreement to extend listings. Respondent states that when complainant recently called about the listings, respondent told complainant that respondent extended the listing, but that respondent did not tell complainant that respondent did not let listings expire. Respondent told complainant that respondent thought they had an agreement to extend listings. After complainant told respondent that complainant did not want listings to continue, respondent informed principal broker below, who removed the listings as only principal broker has control on MLS listings. Principal broker told respondent that principal broker believed there was a written agreement and expressed disappointment in respondent. Respondent states respondent told complainant that the DOM date would revert to 0 when relisted with new agent, and that the other sites like Zillow or Trulia were out of respondent's control. Complainant then told respondent to purchase properties, and respondent refused. Respondent states complainant then contacted principal broker, who asked respondent to have spouse talk to complainant, as complainant stated she could not understand respondent due to an accent. Spouse reiterated that DOM would revert to 0, and complainant did tell spouse to purchase properties. Respondent states principal broker, who is involved because of respondent's actions, has had serious health issues, including the stopping of the heart. Respondent states principal broker is scheduled for serious surgery, and that this illness has meant the principal broker has been away from the office, but has always instructed affiliates to act ethically and to obtain proper paperwork. In rebuttal, the complainant states the spouse did tell complainant that respondent never let the listings expire. Complainant states respondent did sell the one property, but that there was no conversation about extending the contracts in question. Complainant states complainant is certain that the principal broker was not aware of the behavior of the respondent. The recommendation is a $1,000 civil penalty for violation of TCA 62-13-4042 for failure to be loyal to the interest of the client. Do you want to go back to your question?
But do you still have a question about the status of the spouse?
Yeah, I was just curious.
And the spouse indeed was a licensee as well, and the rest of that was failure to be loyal to the interest of the client and putting the interest of the client first, because I don't think that this person did that. Yes, the respondent's spouse was also a licensee in the same office.
Okay, all right.
Other questions, or is there a motion?
Yes, I'd like to add, take another course on contracts to this recommendation of the $1,000 civil penalty and do it in 180 days. And, I mean, the rebuttal that we always keep our listings current, we never let them expire. I mean, that's, you cannot have a listing ad in, forever.
All right, so there's a motion by Commissioner Bloom for a $1,000 civil penalty plus additional 4 hours of education in contracts above the other requirements to be completed within 180 days. Is there a second? Seconded by Commissioner Taylor. Any additional discussion?
Commissioner
Bloom,
Wood, did you think at all, because there's 2 lots, that it should be
$1,000 times 2? That's fine with me. That's fine with me. I was looking for more.
Okay. Can we change that? Can you change this motion?
Ms. Ryan, could we justify 2 violations there because of the 2 lots?
I think it's actually 1 violation just because there were 2 lots. It was 1 listing for those 2 lots. I mean, it was all part of the same contract. I suppose you could make an argument, but I honestly believe it was 1 transaction and 1 issue that was not addressed properly.
Is there an advertising violation because they were listing properties for sale that they did not have under contract to sell?
I think you can make an argument that was an advertising violation, but it wasn't as blatant on that, which is one of the reasons I didn't include it. But you certainly could make the argument that since it was kept up on the site with no modifications and nothing agreed to by the complainant, yes, it could be an advertising violation. And you could then add additional $1,000 for that. It would be more easy to argue.
Bloom, would you like to do that?
That's fine with me. $1,000 civil penalty for the advertising violation, $1,000 civil penalty for violating TCA 62-13-4042, and then a 4-hour course on contracts in 180 days.
Taylor, that's your second to that motion? Okay, any additional discussion? Let's vote. All those in favor of the motion vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Number 7, please, Ms. Smith.
2017-053961. The respondent is the principal broker for the above affiliate. Respondent admits that respondent should not have extended listings without the assurance of a written extension. Respondent states respondent has had health issues and did have full cardiac arrest earlier this year. Respondent states that complainant did call respondent and complainant threatened to file this complaint unless respondents purchase property. The recommendation is a $1,000 civil penalty for failure to supervise.
Could there be, since all advertising is under the control of the broker, could there be an advertising violation by the broker as well?
Yes, I think since we included it for the broker, you could include it for the principal broker as well.
I make the recommendation that we give the exact same penalty as above, which is $1,000 for the failure to be loyal to the interest, $1,000 for advertising, and the 4 hours contracts course.
Well, actually, the recommendation was from me for failure to supervise.
Failure to supervise. Okay, yeah, failure to supervise, but failure for advertising and the 4 hours contract course.
Okay. Motion by Commissioner Taylor, seconded by Commissioner Bloom. $1,000 civil penalty for advertising violation, $1,000 civil penalty for failure to supervise, an additional 4 hours of continuing education above the other requirements to be completed on the subject of contracts within 180 days of executing the consent order. Any additional discussion? Let's vote. All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Okay, what's going on with number 8, 9, 10?
If you don't mind, let me address that, and then Erica can read it in. 8 and 9 were presented in December, as was number 10, but somehow number 10 got left off. The legal report is presented to you all. So these are being represented to include number 10 in this particular matter. 8 and 9 were agreed by you all to have litigation monitoring in this particular matter. Number 10, I will, if you all please, I almost called you the court. If you all please, 2017-04074, the respondent is the principal broker to the 2 respondents who are under litigation monitoring, and the respondent firm is a part of that litigation. So my recommendation is for litigation monitoring for this particular matter.
A motion for litigation monitoring. Okay, we've got a motion by Commissioner Hill, seconded by Commissioner Wood for litigation monitoring on number 10. All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously.
Want me to read the
number on 11 and then read the
And 12.
and 12 and then yeah, do that.
Okay. Did you want me to read 10?
She read the number.
Oh, okay. So you said 11 and 12?
Yes, ma'am.
11 is 2017-04074. Number 12 is 2017-018941.
No, you have those. I'm sorry to interrupt. Number 11 is 2017-018941, and number 12 is 2017-018961.
Okay. The recommendation on both of those is to dismiss. Is that correct? Based on the outcome of the litigation.
Motion to accept council's recommendation.
Second.
All right. Motion by Commissioner Hill, seconded by Commissioner Wood to dismiss 11 and 12. Discussion? All in.
On
Yes,
on
Commissioner
number
Bloom.
11, was there an offer not disclosed to the seller?
No.
All right.
And that particular issue, you should know, was also included in the litigation, and everything was dismissed and taxed against the plaintiffs, I believe.
Okay. The motion is to dismiss 11 and 12. Any additional discussion or questions? Let's vote. All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. At this point, can Ms. Ryan be dismissed?
Yes.
Okay, thank you, Ms. Ryan. Have a good day, and I hope all continues to improve with your healing.
Thank you, and I'll see you all in February. Thank you.
Thank
for
you.
my
We'll look
patience.
forward to
Your
it.
Patience. Okay. Bye-bye.
Number 13, please.
Okay, I'm worried that I printed out. Okay, 13. Okay, number 13, 2017-047-131. Complainant sold her home and respondent is the buyer's agent. Complainant explains that she hired movers who were delayed in getting her property out of the home by an estimated 4 hours due to inclement weather. Complainant alleges respondent's husband, and child arrived on their own accord without complainant's permission and packed boxes, loaded property into the moving van, and damaged property during the move. Complainant also states respondent told the movers to leave the complainant's washer and dryer in the home, even though these appliances were not supposed to remain and were not included as part of the purchase in the contract. Counsel confirmed the washer and dryer were not supposed to remain based on the copy of the contract provided by both complainant and respondent. Respondent states the complainant's agent called her and asked her to help get everything out of the home since the movers were delayed and the buyer had planned on moving her property in at a certain time with a moving truck. Respondent states she was headed to dinner with her husband and child, but they stopped by to offer the assistance the complainant's agent requested. Respondent further states that when she arrived, there were only a few items left to move. She and her husband picked up trash and swept, while her daughter disassembled a crib with the permission of the movers. Respondent denies damaging any property, but states a box that the movers packed came apart in the driveway and kitchen items came out of the box. While the movers were finishing up, respondent and complainant's agent were talking over the final room checks, and the washer and dryer were the last items in the home. Respondent pulled up the contract on her phone, and respondent's interpretation of the contract led her to believe the washer and dryer were to stay with the house. Respondent alleges complainant's agent asked respondent if the buyer really needed them, which she did, according to the respondent. Respondent states she asked complainant's agent what they should do, and complainant's agent said, quote, "I guess leave them," end quote. Respondent was informed the following day that the complainant was extremely upset about this and demanded respondent pay him $350 for the washer and dryer. Respondent states the next day she was contacted by her principal broker and informed complainant now demanded respondent return from a distant city she had just traveled to immediately to pay the $350 and apologize to the storage company in person. Respondent called the storage company to apologize, but they were closed. It was the weekend. Complainant was then informed of such by the principal broker, became irate, and hung up after stating he would handle it in his own way. Respondent has paid the $350 to complainant. Although counsel does not understand how respondent could have interpreted the contract to state the washer and dryer should have remained, complainant's agent told her it was okay to leave them, and she complied with the complainant's request regarding paying the $350. Therefore, counsel recommends a letter of warning regarding exercising reasonable skill and care in providing services to all parties to a transaction. So the recommendation is a letter of warning for violation of TCA 62-13-4031.
More than that, frankly, because the agent should have paid the $350. She's the one that made the mistake. That's one thing. And
The agent did pay.
well,
Yes.
I still think the agent was not careful in asking people to help move stuff out of a house, and we don't know legitimately whether the house was by law closed. So it could have been. I just feel like she needs more than a letter of warning.
I don't guess they filed a complaint against the listing agent,
No.
and the listing agent was right there too, and they had the discussions about the washer and dryer, but
because when I first read this, like I said, I cannot comprehend how anyone could look at that contract and think that the washer and dryer were supposed to stay, because other appliances were listed, there were other things listed, and it was clearly not there. But the fact that the complainant's agent was fully involved in the decision making and also, went along with it, asked if the buyer needed them, and the respondent has paid the complainant $350, truly tried to comply with some of his demands were pretty ridiculous, but did do all of that. I kind of felt like a letter of warning was appropriate, but I would understand if a civil penalty is necessary.
So when you reach out to help, and when someone asks you to help and then you do it, and then it turns around and bites you.
Right. Yeah. I mean, the seller's agent definitely asked her to come help. I mean,
How do you know that?
will you pull up the file? Sure, I have some emails, but I'm gonna verify that before I speak.
Commissioner Horn, you have a question while they're checking on that? Okay. All right. I've got your motion, Commissioner Horn. Is there a second to accept the council's recommendation while they're looking for that information? Or we want to hold on it? All right, Commissioner Douglas has seconded it. All right, so we've got a motion on the floor. Let's get this information in response to Commissioner Grease's question.
While
Yes,
she's
Commissioner
researching.
Douglas.
I mean, do we have a copy of the contract? And was there any temporary occupancy agreement, or do we know it had closed? And
There was no temporary occupancy agreement. Sorry, I'm trying to. Well, I don't have anything that is in writing or evidence that the complainant's agent, in fact, invited them, but the complainant is provided an opportunity to rebut, and I guess just based on everything that I read, I feel like the complainant would have absolutely called out the respondent and said, no, my agent did not ask for you to come help, and that was never said. It was just that I didn't ask.
Was the house truly closed? Do we know that?
Well, the seller was supposed to be out by, I think it was 8 p.m., and there was such a heavy downpour that it was delayed at least 4 hours, and that was made known to everybody as soon as the weather was, obviously bad. So the buyer coming in was a single mom with a little kid who had arranged for a truck so she could move her stuff in based on the time frame that the seller and seller's agent gave them. And this was even after they knew the weather was bad. The buyer was willing to wait a little bit longer. So it just seems to me that everybody was just trying to help everyone out by getting everything out of the house so the buyer could move in.
go ahead, Mr. Chairman.
I could be real cynical and make a case, but to me, it boils down to this lady looking at a contract, or man, whatever the case may be, and not being able to read what that contract says, right?
That absolutely is the case here.
So if Johnny wants to put a recommendation out there, we accept your council's your recommendation. At the very least, I would like to amend that to include a 4-hour contracts course as some sort of suitable part of the penalty process. I'm not sure it's enough, but that's kind of where I'm going at this point.
Mm-hmm.
So I'll go ahead and make that a motion.
Well, Commissioner Horn, you have a comment?
Somehow, the person the way I'm reading this is that one thought the washing machine stays, the other one thought the washing machine goes.
Whether that's true or not, our attorney says there's no way that anybody with any sense at all could read this contract and not see how clear what the contract said was supposed to happen. I believe that's what Ms. Smith said, in my words, not hers.
That's
and they
correct.
Said he pulled it up on the phone and looked at it.
The respondent said, "Oh, I pulled it up." It seemed like they looked at it together, but it was her statement that my interpretation was that the washer and dryer was to stay. I have no clue how she could come to that conclusion.
But we don't have a copy of the contract, right?
No, I do.
Oh, you do? I
Yeah,
thought you said
and
no
that's
a
why
moment ago.
I'm
Oh.
making such a strong opinion.
Okay.
I've read it over and over and looked at it so many times, wondering how somebody could think that.
I was just thinking there's some he said, she said type stuff here. You know, did they actually ask for help? But also, was it actually raining and was the truck actually delayed? You know,
But both the complainant and the respondent are in agreement about the weather and the delay. All of that is there's no dispute there. Just the complainant is mad that the respondent came into the house, I think, and helped.
I think I was kind of thinking along the line what Commissioner Grease was. Sometimes we bring our knowledge and everyday work of real estate to these meetings, and sometimes we find agents that sometimes they get out of their lane. I mean, and they really, I'm like, why in the world is a buyer's agent over moving the seller out? Maybe they got invited, but I'm like, you're not the moving company, and it's not your side.
Right.
Get out of the way.
Right.
So I don't know. I like the idea of adding the education.
So, Mr. Horn, you wanted to stick with the original recommendation of just the letter of warning, right?
Yes, and one of the things I think that we are overlooking is that many of us got contracts that we have no idea what it says. Now, when it comes to be a problem, then we get the help in the fine print. If the person assumed that there was no problem with the washing machine and it was his, I'm sure he didn't get the contract and go, washing machine, washing machine, washing machine. He just assumed what he saw was left. And the only thing that I'm saying here, I realize somebody needs to pay because you're going to get a pound of flesh out of them. I understand that. The idea, again, is did somebody tend to fraud or steal, etc., simply because he assumed that he had the rights to the washing machine. Now, just like you said, as a realtor, you could see that, oh my goodness, how could that happen? But as me, being a public person, I could see how it could easily happen. Somebody come in, see this equipment sitting here, and probably needed a washing machine at the time. He didn't go and check no contract. He just went on and took it.
That's stealing.
I'm a little concerned because it looks like, according to the respondent, and nobody has said otherwise, there's a lot of that going on in this case, but the respondent said that the complainant's agent is the one who said, I guess we leave them.
And the complainant had every opportunity to rebut that and didn't.
And the complainant's agent is supposed to be acting on behalf of the complainant.
Right. That's kind of why I leaned towards the letter of warning. If the respondent hadn't have paid $350 to this complainant, I would absolutely recommend a civil penalty. But
All right, well, I'm going to do this. We've got the original motion by Commissioner Horn, seconded by Commissioner Douglas for the letter of warning. And then I'm going to interpret as a substitute motion from Commissioner Grease, seconded by Commissioner Wood, to do a letter of warning plus a 4-hour continuing education class in contracts above the other requirements. We're going to interpret that as a substitute motion. We're going to vote first on Commissioner Grease's motion. And if that fails, then we'll come back to Mr. Horn's motion. So we'll figure out if people want to add on this education or not. Let's do that. All right, any additional discussion on the substitute motion, which would include the 4 hours of continuing education? Let's vote. If you're in favor of the letter of warning plus the 4 hours of continuing education and contracts, vote aye.
Aye.
If you're opposed, vote no.
No.
No. That motion carries 5 yes, 3 no, with Horn, McMullen, and Douglas voting no. Is everybody okay with that? All right, let's do number 14 now, please.
2017-047-151. Respondent is the principal broker for the affiliate broker in the complaint above. Respondent feels the affiliate broker did everything with good intentions and with the agreement of the complainant's agent. Respondent denies failing to supervise the broker and worked with the complainant to the point he hung up on her and refused to speak with her. Counsel finds no evidence that respondent failed to supervise the affiliate broker and recommends dismissal.
Accept counsel's recommendation.
All right, we have a motion by Commissioner Hill, seconded by Commissioner Taylor to dismiss. Any discussion? All in favor vote aye. Aye. All opposed vote no. That motion carries unanimously. Number 15, please.
2017-052431. An anonymous complaint was received on August 4th, 2017, which is simply in the form of a photocopy of a sticky note which states respondent's name and, quote, no license under name, end quote. Attached to the photocopy are copies of screenshots from respondent's website, which include the following: a screenshot of the main page showing the business address, the phone number, and email address, and the business hours, along with a statement that reads, quote, call for appointment, end quote. The second is a screenshot of the property management page, which reads, quote, in addition to leasing properties and performing renovation work, we offer property management in the local and surrounding areas. Some of our management services include advertising vacant properties on our website, in our voicemail, on yard signs, and on social media, meeting with tenants for them to fill out our rental application, provide proof of income and discuss their property needs, screening prospective tenants, including collecting and dispersing tenant security deposits, handling all tenant issues, handling all repair work in a timely manner with our full staff maintenance crew, and providing monthly statements to the property owners, end quote. And the third is a screenshot of the About page, which reads, quote, we are a company that manages rental properties and performs renovation projects in the local area and surrounding areas. We have 2, 3, and 4 bedroom single-family properties and 1 and 2 bedroom multifamily properties available. We also specialize in Section 8 rentals. Owner has been in this business for 15 years, and he has developed an impressive reputation in the rental market in the local area, end quote. The fourth is a copy of a business card for respondent with the same contact information as the website. And last, a screenshot of respondent's Facebook main page. Respondent responded to this complaint by simply supplying copies of its standard business tax license with the local county clerk issued April 21st, 2017, and a copy of another city's business tax license issued the same day. Counsel finds evidence based on the information provided on respondent's website that respondent is engaged in unlicensed activity by offering property management services for properties it does not own, and recommends a civil penalty for unlicensed activity. So the recommendation is a $1,000 civil penalty for unlicensed activity with a cease and desist statement.
My counting, if the way I'm looking at it, they've got at least about 5 properties that they're saying that they manage. They got a 2 and a 3 and a 4, and then a 1 and 2 bedroom multifamily. They're admitting to at least 5 properties, and so
I think probably even more. If
I
went back and looked.
I'm also looking at what they said they've been doing it for 15 years.
Yeah,
So if they did one deal a year, that's 15 violations.
I would imagine if I went to the website, we would find at least 5, 10, 15, probably.
oh, how many do you recall seeing on their website, Erica?
I feel like I can say for sure 4.
Backing up on me. I got 5 already. Okay. I'd like to make the motion of a $5,000 civil penalty for unlicensed activity.
All right. Motion by Commissioner Wood, seconded by Commissioner Hills for a $5,000 civil penalty. Any discussion? Commissioner Bloom?
Well, I want to add that cease and desist.
And the cease and desist. Yes, that's included. Sorry. Okay, $5,000 civil penalty and a cease and desist statement. Any additional discussion? Let's vote. All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Number 16, please.
Can I say
Yes,
this?
Commissioner Wood.
In case there ever happens to be like some type of representative in our state that ever watches this kind of stuff, I mean, I'd like for them just to note, look how many times today we've had unlicensed activity, And for some reason, the word is out there that if you have a business license, you can collect money and distribute money for. I mean, and one of them today said, "Well, I'm not selling it. I'm just collecting their money and stuff." I'm obviously the penalty's not getting it. We don't have enough teeth in this, and I would like for somebody to consider partner with us and trying to help fix this problem. We got a problem.
It seems, and from my experience, it seems like it's mostly property management.
Sure, there's a lot of that
You
right
know,
now.
that's, and it's the most, they're like obvious and out there. They truly don't, I don't even know if they know that they're doing anything wrong.
Outreach people.
I think
would-
that should be Bobby's topic at the TUR spring meeting.
The TUR.
Just give me the podium, I'll start preaching, and then Johnny and I will take up an offering afterwards. We'll take care of this problem. That's right.
Okay, number 16.
2017-050-721. An anonymous complaint was received on August 2nd, 2017 from a concerned citizen stating that respondent appeared to be conducting real estate and gun auctions despite having an expired license. Complainant attached copies of advertisements as follows: an advertisement for an Absolute estate auction on June 15, 2017, an advertisement for an Absolute gun, ammo, gold, diamond, jewelry, and coins auction on June 24, 2017, and an advertisement for an estate auction on August 12, 2017. Our department was also sent a copy of the complaint. Our department also sent a copy of the complaint to the Auctioneer Commission, and a letter of warning was sent to the respondent from the Auctioneer Commission on October 17, 2017, regarding Tennessee Code Annotated 62-19-102A1, which cites licensing requirements for auctioneers. And that was my case, actually. So I was the one that actually presented it and made the recommendation and sent the letter. Respondent responded to both complaints on August 4th, 2017, and stated that as soon as he received the complaints on August 3rd, he contacted our licensing division about his expired real estate firm license. Respondent states that he did not realize his firm license was expired until he received the complaint. Respondent states that it was an oversight on his part, and he immediately filled out the renewal application and paid all fees due. Respondent's license was reinstated and is currently active. Respondent states he understands it is his responsibility to keep up with the licensing requirements whether he receives a notice or not. I asked respondent to estimate how many auctions he had conducted between March 2nd, 2017 and August 9th, 2017, when his license became active again, and respondent estimates that he conducted 4 auctions. Council takes into consideration respondent's complete cooperation and transparency throughout the investigation of this complaint and the fact that respondent has never had any issues with his license prior to this complaint. Council therefore recommends a letter of warning for violation of Tennessee Code Annotated 62-13-301 for unlicensed activity.
Pay the fees.
Oh, yes. I think it was within 24 hours of him receiving notice of it, and I verified all that in our system. He did it for both the auctioneer and the real estate.
Move to accept.
Second.
We have a motion by Commissioner Bloom, seconded by Commissioner Hills to accept the recommendation of a letter of warning. Any discussion? All in favor, please vote aye.
Aye.
All opposed, vote no.
And I have a question.
That motion carries unanimously. Commissioner Hills.
So what then triggers, or does anything trigger with our system that licensees under the firm's license, so nothing ever triggers that those licensees don't have a active firm license, that they're hanging under an expired
I see what you're
thing.
saying. Like,
So
our
nothing
system
in our
isn't-
system ever sends a flag up, right? So it just keeps going. Okay. I know when I was around, when we changed our dates of when our license was to renew, and it had to do with E&O and things. It seems like we can be baptized one time and change it back somehow to something that makes sense to us, to my birthday or something that still would not affect our E&O, that everything comes due at one time again. Something that could make sense to each individual licensee, and we just take a bath in at one time so that people don't have such an odd time, that people don't come up and say, oh, I didn't know that was the time my license expires. Because it's like herding cats, always. I wish we could do something.
Do you want to put that on next month's agenda to talk about?
Yes, I mean, and if it makes sense for us, it's got to make sense for the whole state,
I think there'd be some things that we'd have to think about with that as far as education goes, because if you just renewed and then it changed to your birthday, we'd have to figure out.
Oh, we lived through it once before. I mean, we did it once. It happened once. We already lived through it one time when they changed it on us one other time. So I know it's possible because we lived through it.
Wasn't it always at the end of the year?
It was because E&O and processing everything at one time and things like that. But it just seems like there's got to be some way now with technology and things that there's got to be an improved way. Certainly we could, because that was years ago. There's got to
One
be
thing
something.
technology allows me to do is to put a reminder on my Outlook calendar that pops up every year when
I
my
know.
when my assistant's birthday is.
Yes,
And so I can do the same thing when my license runs out.
I know.
Technology is an amazing thing.
It is.
More importantly, your wife's birthday and your anniversary. Just
I can remember that one without the calendar. But Chairman Grease, I turn it back over to you.
Good job, Commissioner McMullen. Thank you, and thank you, Commissioners, for working basically through lunch. But the good news is we're just about finished. I did notice that
Not noon yet.
It's not noon yet where you're from, but it is where I'm from.
Where we are.
Yeah.
It's not noon.
I understand. We have Mr. Carter Lawrence here with us, who I assume came down to wish us a Happy New Year. Or what are you doing here, Carter? Anything you want to tell us?
I'd known I was going to come up to the podium. Maybe I would put on a coat and tie.
They're only
in order
seeing
to
your back, so you're
show
okay,
respect to the esteemed commissioners. I was just coming down to say hello. I had asked Caitlin to give me a heads up when y'all were about to be breaking, and she was kind enough to text me. So I just wanted to come down and say hello to everyone. Hope everyone had a very good holidays, and that I was just happy to see everyone, I guess, except for Marcia. I hope she's well, but to see everyone else here. She is very well then.
better than the rest of us right now. So
Oh, and I should, since I see Aaron here, also let you commissioners know that Trek broadly and Aaron specifically was helpful in the organizing and planning of the first inaugural Reg Board's division-wide holiday party. And it was Aaron who led the way on doing our party planning and decorating for it. So
Don't go, Aaron. What budget were you given to work with? How many dollars? How many?
Never mind, this is paid directly out of the assistant commissioner's pocket.
That's why I wanted to. Okay. So somewhere between $50 and $60 is my guess.
Sounds like fundraising was a big part of the job.
Going forward.
So, would you like to give your assessment of how the Real Estate Commission office is working at this point? I have
absolutely.
mine, but I'd like to
Yeah.
get your take on it as well.
Yeah, I think that everything is running very smoothly. While there have been a couple fluctuations in metrics, I think those are largely related to the holiday season and some staff outages. And when I talk about fluctuations, very minor. I'm very happy overall with the performance of the program and continuing to license and do our complaints, managing all of the process in a very timely and customer-focused manner. So I think it's all going very well, and I think you're still, can I still say new? Executive director is not new anymore. Your executive director is doing a very good job, and credit to the commission there.
Well, my sense is the same, particularly because you haven't called me to focus on a particular topic or two that I seem to have, in the past, got a lot of calls about. So I'm glad to get your perspective on it as well. I'm glad the commission heard it as well. We're still free to call you anytime we want to.
Absolutely.
I just want to make sure of that as well.
We'll see if there's legislative reasons to call me here pretty soon, as y'all are aware, session started yesterday. So we'll be finding out what is going to be impacting the profession here pretty soon.
We appreciate you coming down and saying hi to us.
Great seeing y'all. Enjoy lunch.
Happy New Year to you as well. Thank you. Now, about that job you had, did it interfere with your regular work?
Not at all. It actually flowed all together.
It's amazing, isn't it? See you, my friend. All right. Anything else legal for us?
I did ask.
Take that microphone and move it towards you just for a second there.
I did ask Rihanna to reach out to the ALJ to find out if they'd be available for the March board meeting date, since Robin will have a hearing on the hearing date for the Willoughby matter. So as soon as I hear back, we will communicate that to you, if you're still okay with that.
Just to reiterate what Robin said, there will be a hearing in February. So, unless you hear otherwise,
Which is about a 50-50 chance, I would think. Caitlin, anything you'd like to finish? Okay. I'm glad to hear Carter saying you're doing a good job. All right, commissioners, last chance to say anything you'd like to before we hit the road. Pastor Horns, great to see you back. Appreciate your input as always. Do you have any words of wisdom for us? Sometimes you have those that catch my attention.
I would just like to say that most of us can remember King's as one that was in the Viking King in the 900s. And most of you have no idea who was the Viking King. But we use his name practically every day. His name was Blue. Viking Lab did name their equipment Bluetooth so that in honor of him, so that we could.
All these years, you still remember that story. All right, Rick, anything?
No, sir, don't have anything. It was a great meeting. Thank you for speaking.
Fontaine?
I would like, thank you for everything, and everybody's done a great job, but I think put on each one of the little things, whether they're on a TA, would give us a heads up when we read it.
Bobby?
Piggybacking on that same thought, I'm assuming that most of the complaints that come in are on a TAR contract, because it seems when we ask, that's what they say. Has there been any thought, and this might be a Caitlin question, but to maybe either having a class brought in or sending Erica and Robin to just a contracts class for TAR, because they change every year. I mean, and we have to go to the classes just to stay up to date. Otherwise, we get behind. And I'm just wondering if that would be helpful for them. And this is not a shot, okay?
Oh.
This is not a shot.
Sarah and I discussed it.
we talked about it with Mark, and so I just
Okay.
need to remind him. And
Okay.
So
I mean, I just see,
Definite.
we use those contracts every day, and you and Robin are such a disadvantage because you pick them up for us, and then you go to another commission and you're doing something. I mean, you're only touching these infrequently, only when there's a complaint. And so I think that might be helpful.
Yes,
So,
I think it absolutely
Okay.
would be, and
Okay.
I look forward to it, so.
Gary?
Well, Sherry, Carter's gone, so would it be okay if we asked the pastor?
Perfectly appropriate.
Difficult surgery.
Thanks, Johnny. Anything else, Gary?
No, sir.
Okay. Diane?
Come in. I'm proud to know Gary Bloom. He was recognized.
Lifetime Achievement.
Lifetime Achievement Award, and I'm just proud to know him.
Thank you.
Mr. McMullen? Sherry, sincerely, you're on our mind, and we wish you the best, and we can't wait for you to get back, all right? Because you're doing a heck of a job for us. We appreciate it. And if there's something that any of us can do, individually or collectively, I hope the staff will let us know that as well. All right, friends, safe travels. See you next month.
If anybody, Melissa should be here in like the next 4 minutes with her baby, if anybody wants to hang around.
Okay.